and welcome back to my channel where we are all crime, all black, all the time.
Our participation in gang activity, which I believe
Oh,
Mr.
yeah, save that one to last. Let's talk about the underlying ones first,
Okay.
if you don't mind.
So I believe his next counter on is possession of a firearm by a convicted felon. And I will address the possession of a firearm during the commission of a felony, and then Mr. Abati will address the 133 possession of a firearm by a convicted felon.
Give me a second. I'm sorry, they're kind of not all together in the indictment. I
No
wanna make
problem,
sure
Your Honor.
of. All right. Go ahead.
Okay, so for count 54, Your Honor, possession of a firearm during the commission of a felony, Mr. Drinks was killed with, I believe, a 40 caliber, I believe, a Glock handgun based upon the GBI testimony that came in. Your Honor, there was testimony yesterday from Investigator Viverito that in a video that's was created about an hour before the murder of Donovan Thomas, that there is a gun that could be consistent with a Glock 27, which is a 40 caliber handgun. That is the evidence that we have, Your Honor. We never recovered the handgun used in this case, Your Honor, but there is evidence. I believe if we look back to the Donovan Thomas murder, that after that murder, they got rid of the gun. It's the state's theory that the same thing occurred in this case, that after the murder of Mr. Drinks, that they did get rid of the Glock handgun that murdered Mr. Thomas. But we do know that he was, excuse me, Mr. Drinks, but we do know he was killed. It is the state's theory that Mr. Stillwell shot and killed him, and would have shot and killed him with a 40 caliber handgun, Your Honor.
All right, and then the other gun one was the one that was tossed or that.
Yes, Your
yeah,
Honor, and then we
tossed
know from Miss,
Right before they were arrested.
right before that, I'm sorry, that's count 60,
Okay, that was registered to,
Miss Taisha Alexander, Your Honor.
all right.
And I do believe for the gang, Your Honor, Mr. Adkins discussed that within the RICO when he talked about
Okay.
the gang. So
Thank you.
thank you, Your Honor.
All right, reply argument.
I don't feel the need to go on and on, but Your
Mhm.
Honor, I just wanted to clarify one thing. I felt that there was kind of a straw man where my argument was being presented about the overt acts alleged, that I didn't, the state needs to give a history, and the jury needs to hear about the history of different acts. I'm not saying that those overt acts aren't relevant. And obviously, I mean, we've been in here for a year. They've presented evidence of those overt acts, many of them, not all of them. My my assertion and my argument is merely that the state should not be allowed to create an indictment with alleged overt acts that are outside the statute of limitations, and then a listing of those overt acts goes back to the jury as part of the indictment. And that's all I'm arguing with that. Not that it's irrelevant, not that they can't get into it, because
Yeah,
obviously they
I
have.
understood that to be your argument. I appreciate that. Thank you.
Your Honor, the state stood up here and gave a very thorough response to our motion for a directed verdict. But they never once, and I was listening very carefully, and you specifically asked them about the constructive possession. They never once made argument regarding any intent shown by Mr. Kendrick on possession of those drugs or guns. They made some arguments perhaps about ability, although even that I think was somewhat strained, where you have firearms that are in cabinets and closets and wherever, and he's just a guest in the home. The issue of intent is one, again, that you're going to instruct the jury on in the jury instructions. You also have a mere presence that you're going to instruct the jury on. So Mr. Kendrick, while he may have been present in the home, there hasn't been any evidence regarding intent, Your Honor.
All right, why don't we take, I don't know if lunch is here yet, but why don't we take a break for a little while? Y'all can see if you can get together and come to whatever agreement you're going to come to on overt acts that there hasn't been evidence presented on. And I want to read the motion that got filed and look at some of the case law. And maybe review some of the evidence. And then, presuming I don't grant the motion on every count, which I think maybe there's been some acknowledgement that at least a tiny bit of one count might be able to go forward. We need to finish the charge conference. You were going to say something, Mr. Sharp?
I was just going to let Your Honor know that I did. Calling it a chart is really giving it way too much credit. But I did email that to Ms. Persfield and the state, and I will update it after I confer with the state and figure out.
I didn't mean to oversell what we had put together last.
It's fine.
One other thing, as far as the charge conference goes, I did submit one additional proposed jury instruction to
I
Ms.
saw that
Percival.
one. I'll be interested to hear your argument on that
Thank you.
and the state's response.
Yes, Your Honor. And on that note, we have discussed the charges for the overt acts
Mhm.
that the jury would not otherwise be instructed on, like armed robbery. I just want to let the court and defense know that the state has and is about to submit
Okay.
to the court parties the underlying crimes of the
Okay.
overt acts that are crimes and not otherwise alleged.
All right, thank you.
And, Your Honor, when it's appropriate, it can be later but could the lawyers from each side approach about a scheduling matter?
Y'all can do that now. And I'll give y'all my ruling on the motion for directed verdicts, motions for directed verdict, and we can do whatever else needs to be done with regard to the charge conference. However, I guess on the do y'all mind doing the overt act thing and then getting that to me and then going to lunch so that I can have that with me? Okay, thank you. First, with regard to the ruling on the motions for directed verdict. So both the state and the defense requested and have gotten a trial in this case before a jury. Is not before the court as a bench trial. So that means that this court is not the trier of fact. And the standard, as you all know, for a motion for directed verdict is not the beyond a reasonable doubt standard, that what the jury is going to be determining the facts on when the case is given to them. The standard at the stage of motion for directed verdict is that all of the evidence is to be viewed in the light that is most favorable to the prosecution. And doing it in that way, looking at it in that way, is there any evidence from which a rational trier of fact could find the essential elements of the crimes that are charged? So with regard to the motion for directed verdict on counts 1, 2, trying to do these in order. Now, let me just do it this way. I am denying the motion for directed verdict on all counts except I'm granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of, that even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items. And let me say that with regard to counts 1, I'm sorry, not count 1, counts 2 and 49, again, is not a beyond a reasonable doubt standard that the court is required to employ in determining a directed verdict as to those counts. I understand the arguments, but it is up to the jury to determine credibility of witnesses, and it's up to the jury to determine what witnesses or what parts of testimony they might believe and what witnesses or parts of testimony they might not believe. So if there is evidence presented that a jury chooses to believe, which is how I have to take it in evaluating this, I have to evaluate it as though the jury is going to believe whatever is most beneficial at this point to the state's case, which means they could believe everything that Mr. Copeland or Mr. Zachary said that would support the state's case. And frankly, they can disbelieve even an expert's testimony. And so I just wanted to add a little more with regard to what my reasoning was as to those counts. So that's, y'all know now what it is that you need to be preparing for closings. And I think unless there's anything else on those matters, that we can turn to the hammering out the rest of the jury charges and sorting out the verdict form. And I appreciate that y'all seem to have been able to determine for a lot of the overt acts, which there is not any evidence of. And so obviously those will get redacted out of the indictment. Oh, let me also say with regard to those gun charges that we talked about earlier, that I am granting a directed verdict with regard to the greater of those charges on the 133. The state even admits they don't have all of the elements for that. So those will be charged as the lesser. It looks like that Martinez case provides that even over a defense objection, the state is entitled to get the lesser charge for those counts. So that's why that's kind of, I guess, a grant of a partial directed verdict as to those counts. And those were the Well, y'all know which ones they were. I don't have them right, right in front of me. What were they?
52, 64, and 61.
Okay, thank you. All right. So I haven't yet seen the proposed charges on the crimes that are set forth in the overt acts. So, Mr. Atkins, we did get, there were some additions or changes with regard to the state's proposed RICO instructions, but have you sent yet the crimes that are just set forth in the overt acts?
The pattern instructions, Your Honor?
Yeah.
Yes,
Okay, maybe we just missed that.
I titled it, Your Honor, proposed, I think, supplemental jury instructions.
All right, well, Ms. Persfield will look for that. I know there are a couple of things we need to circle back on the non-RICO part of the jury instructions, but let's do the RICO part first, if you don't mind. And I keep further editing my proposed RICO jury instructions. So y'all have the latest, I'm not going to say greatest because it may not be, but the latest version of what the court is thinking about charging. So if we want to open that up and kind of start there, and then I'll listen to whatever anybody wants to suggest should be in or out or said differently. Now, Mr. Atkins, I wasn't quite sure I understood your teal. I didn't know if you were saying, oh, the court struck through these and we think they should be included, or what exactly the teal comments were.
Your Honor, the teal, I tried to capture either items the state believed
Okay,
should come out
All right.
or words that the state added.
okay, so we maybe just, as we walk through, you just bring them up to me
Yes,
as we get there. All right, so if we want to all get to that document.
Mr. Floyd is going to take the
Okay.
lead on this part.
And you know, since you just emailed us, is it all right if I remain seated because then I can see
That's fine.
the screen? And
Yeah.
are we going to go through what the state emailed to you first, or are we going to go through what you just?
What we're going to go through is what I am proposing, and then to the extent that y'all want to add or subtract or modify, y'all tell me. So I can open up as well. I've got multiple screens up here. The state's latest proposals as they modified them, and then the defenses as well. I think those are the same as they were a couple of days ago.
Okay. Well, Your Honor, since we had submitted those, I can go through those and explain what our thinking was.
Okay.
And the first one is, I'm going off of.
Let me find it first, if you don't
Excuse me,
mind.
Mr. Floyd, which document are you referring to?
I think it's something Mr. Atkins sent us. Is that right, Les?
Oh,
Okay.
that's nice. One we said last night.
Can you give me just?
Yep.
It's called Jury Instructions RICO Draft is what the reline for the email is. And then it's got an attachment.
Thank you.
So that's not RICO, that's the one.
I'm, I'm assuming the one you're referring to is the one. Oh my gosh. Which one?
There's 3 documents. The court's version of the RICO charges, the one that Mr. Atkins sent last night, that was jury and, no. Sorry. That was the jury instructions RICO draft for Mr. Atkins. And then there's also more really for additional instructions that relate to some of the overt acts.
That's correct, Mr.
Okay. All right.
And so as I understand, we're going to talk about the state's RICO instructions that Mr. Atkins sent last night.
Sure.
And approximately it's the one. Okay, thank you.
That sounds right. It certainly felt like about 8:20.
I felt like midnight.
And it's got yellow and red and teal and it's multicolored. That's
It's,
the one.
it's, it's, it's a potpourri, Your Honor. Most of these, despite the color variations, it's pretty simple, I think. The first one that the state proposed some changes to state RICO conspiracy, and I noted that the court had said needs to be tailored to indictment language.
Uh-huh.
I took that.
That was really early on.
Okay, well, but I think it was correct too, because
Mhm.
what was there prior to any modification is just a recitation of the statutory language or something very, very close to it.
All right. So if you would do me a favor and looking at the state's proposal, do you feel like that captures everything that needs to get captured?
I think it does.
Okay.
And what we were looking to do is just remove language that is in the statute. but
Right.
Does not
Agreed.
apply to this case
Mhm.
as it's been charged and presented.
Okay, so,
It just simplifies it. That's
yeah,
all.
so I mean, what I'm proposing is the state must prove that the defendant and then list out the elements. Knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the conspirators committed an overt act to further a criminal objective of the conspiracy. So I think that gets rid of all of what was not applicable from the statutory language.
I think that's correct, Your Honor.
Okay.
Um,
And then, a similar thing for the subsection B.
Yeah, the
Okay.
only, we've been using the word tweak.
Mhm.
In the language that tracks subsection A,
Yeah.
3, personal property,
Mhm.
money or other personal property, this may just be semantic. I think the statute actually says personal property including money, which includes money, but this starts with money. The statute starts with personal property. It encompasses money. It's not a big deal.
Yes. Money is personal property, which is why it says money or other personal
Fair
property.
enough.
Okay.
And as to the elements of B, yes, I think you captured that as well.
Okay.
Your Honor,
Yes.
regarding this, I just had one issue as well. I didn't know
Sure.
if- Before we move on, are you done?
I'm done with this, John.
Okay. Your Honor, I would ask on number 6
Yep.
of the elements,
Mhm.
well, I don't know, I haven't abandoned my argument, but if we're gonna allow all the whole list of overt acts on the indictment to go back to the jury, I would ask.
Well, not the ones that y'all decided there's no evidence of.
Right, but the ones outside the statute of
Yeah.
limitations, I would ask that, on number 6, it's committed an overt act on or after May 10, 2017, or
True.
within the applicable statute of limitations.
True.
Yeah, the only thing I'd point out is you've got that later.
I do.
And so, I mean, I agree it has to be somewhere. It's the question is where.
Well,
Well-
I mean, the idea with listing out the elements is when they're deliberating, they can go right to that and go, all right, here's what we need to be thinking about. So,
Which is why I think Mr. Shart's
Yeah.
suggested edit is useful.
so I had written down the dates. It's like between May
It'd be May
10th of 2017 and May 9th of 2022.
It would be within 5 years of the date of the indictment.
No, but let's
Right,
give them the
which,
dates.
why not just give them the date? Why make them do math?
Yeah.
All right.
Nobody wants to do math here. We're all
The cal-
lawyers.
The calendar in my head wasn't functioning properly.
Yeah. I mean, the indictment, the original indictment was what, May
May 9th.
9th? Okay, so,
If that captures that 5-year window, we have no argument.
okay.
But the indictment doesn't, the indictment says, said accused together with unindicted co-conspirators in the state of Georgia and county of Fulton. You mind if I said?
Go ahead.
On or between the 24th day of January 2013 and the 8th day of May 2022. So maybe the cutoff
Okay.
date should be the 8th day
So
of May,
then May, what would that be? May,
May 8th, 2022.
no, for the beginning, May
Oh,
9th,
it would be May
2017.
9th, 2017. No,
I do too, May 10th. I don't think they're,
May 9th.
and May 8th. And honestly, the dates don't, and I'm saying May 9th, 2022.
Your Honor,
Yes.
the evidence demonstrates the conspiracy continuing after that. The evidence that's been admitted demonstrates the conspiracy continued after that. That's
So what's the law on, is it within 5 years before the indictment, or is it within 5 years before the indictment?
It's before the indictment is what the cases say. I mean, if you look at, I believe it's Conzo,
But
that's the case. and-
continuing on up until the jury gets the evidence.
Yes.
Well, I would disagree with that just because it's specifically pled.
Yeah.
In the indictment, it says, in the RICO charge says, for the said accused together with unindicted co-conspirators in the state of Georgia, county of Fulton, on or between 24th day of January 2013 and the 8th day of May 2020.
yeah, and with that, and with that specific date in there, I would think that anything after the 8th day of May 2022 should not be considered.
Thoughts?
Yes, Your Honor. The fact of the matter is that we did not allege that the conspiracy ended, was terminated, or abandoned. And the jury can look to subsequent acts as evidence as well. I mean, up to and including, for example, Mr. Copeland's testimony. If the jury concludes that Mr. Copeland was lying and that was in furtherance of the conspiracy, they could consider that. Case on that is State v. Cagno, C-A-G-N-O, 978 Atlantic 2nd 921, to New Jersey 2009 appellate case, which involved the untruthful testimony of a witness during an actual trial. And the court looked to that and said that where that witness was part of a criminal organization and the evidence indicated that he was lying to protect the criminal organization or any of its members, that could be considered even though it ran all the way up.
Do you have any idea how that case was indicted? Like what the language of that,
I-
if that,
In truth, Your Honor, I have not seen any. I mean, that is, you know, I understand your question. But I think, I don't think there's any question that presented and admitted in this case that runs.
Some elected indicted action given by this indictment and that they elected to put in here. We didn't pick this date is the 8th day of May of 2022.
In addition, beyond, oh, no, by the 8th day of Q2, it's our state that any overact has to be pled in the indictment. And so, that date.
Your Honor, to plead any overt act specifically in the indictment.
Right.
It's simply not a requirement. And therefore, the fact that there isn't one after the 8th specifically alleged, although we do in the superseding, we have the 9th there. They have notice of that.
They do.
Acts 183 183 through 189, the dates are given on those acts, and they are May 9th.
Yeah, Mr. Floyd is exactly right. They do have acts that are specifically listed in the indictment on May the 9th. But despite that, they still chose to put May the 8th in as the timing of the conspiracy. And it's the same way that they have overt acts that predate the statute of limitations that they've placed in there. I'm sure they have good reason for that. But you know, they could have additional things in there. So again, they're the ones that elected to place May 8th as the end date.
If I may just jump in, I'm under the belief, and maybe I'm wrong, Your Honor has granted a directed verdict for May 9th.
Not all of it, some of it, but not all of it.
Those overt acts would be coming out of.
No, because Mr. Kendrick, I mean, if they determined there was a conspiracy and there were other conspirators, even if Mr. Kendrick wasn't the one guilty of any of these, somebody who might be a conspirator could have been. All right. So I don't think that most of the times dates in indictments aren't material anyway. So I would think it's between May 10th, 2017 and May 9th, 2022. And I need to, that's all of the overt acts that are pled. So you're saying overt acts that aren't pled can support the conviction
Yes.
if there is to be one, as long as they are within, what, 5 years after the indictment?
There's no time
There's
limit
no-
afterwards. I mean,
It's
there's
just,
just overt acts.
Yeah.
And I mean, I understand why the defense desires to put a box around this. The law doesn't put a box around this in the way that they convictions were affirmed based on overt acts that did not appear anywhere in the indictment. I mean, there just has to be an overt act. Overt act is really
yeah.
evidence. That's really what it comes down to. So here, this evidence is in.
I just don't see how, and I understand conceptually, but how does the jury say, okay, here's the overt act that we're all agreeing. It's just something we heard in the evidence that how do we even know?
Matter. I mean, I think. I'm trying to think of. There's a million aspects of evidence in here. Actually, the case this long, a million might not really need hyperbole. that they're going to look at, but we're not going to ask and say, did you find, that's not.
All right, so can y'all come up with some language that succinctly and non-confusingly says, the what, earliest, May 10th, 2017? That just makes it really awkward.
I just
So
also
I
need,
don't know how to say that exactly.
I just also need to clarify that I'm not trying to put the state into a box. I mean, this is the box of the state's own construction that
I believe you previously had a charge that explained that. I don't see it in, yeah, I don't see it exactly in those. The ones that the state had submitted, I believe there is one on it there, but the only concern I have, and it's not a huge one, is that as to item 6, on the 2, you're going to be saying the same thing twice.
What do you mean?
Not a big problem.
What do you mean?
Committed overt act after prior to the indictment. You would say it twice there instead of once in a statute of limitations related charge. That's all.
I don't know what you mean.
I'm sorry.
I don't know what you mean.
I thought what we were talking about, and I apologize if I've lost the path here. In item 6 is committed an overt act, and the request was after a specific date that would place the overt act within 5 years of the indictment. Okay. And I'm just suggesting you could say that once in one charge that's related to statute of limitations, or you could say it twice in each of number 6 because they're identical. Committed an overt act.
All right, where's your statute of limitations language in the state's proposed instructions? Because I don't see it.
I apologize. Neither do I.
Okay, didn't think so.
There was, I'm thinking one, I know I've seen one, I guess it wasn't in this version. But the state does not disagree that an instruction that says the jury has to find an overt act within 5 years of the indictment is appropriate. That's fine. We're not disagreeing with it. It's simply how the exact language is crafted and where you place it in this sequence.
Well, I think it's probably easy enough to say committed and as number 6 to both of these, committed an overt act after May 10th, 2017.
Okay.
I would suggest, Your Honor, that, it's the law. So I think we definitely want to make the jurors aware of the law as they're judging this case and the correct law. They, again, and as lawyers, fully acknowledging that many of them, based on the date, cannot be that overt act. And we will not be back there to explain it to them. So I think we need.
Well, we can explain it to them before we send them back then.
Well, right, and I think we need, my point is, with the jury instructions, I think we need to make that very.
So we might
clear.
want to add something. Many of the overt acts
Well, I was saying.
listed occurred before.
Mr. Floyd seems to want to
Alleged.
just say it once and make us pick. What I'm suggesting is, we say overact, and then if we want to say within the applicable, but in,
After May 10th, 2017, and I'm going to say it right in that list.
okay,
Isn't that what you were asking anyway? I mean, I know you wanted
it's, af-
close brackets at the end of it.
I think it's important that we put it there. But in
Mhm.
your, in court's proposed charges, you also have a separate charge about the statute of limitations for overacts. I'm pretty sure I saw that in your,
Oh, that was,
that was in the one that you sent a couple of days ago.
don't look at that. Look at the one that Ms. Percival sent to y'all about 10 minutes ago.
The one you sent today, it's in the second to last paragraph highlighted in
Yeah.
yellow.
And yeah,
Unfortunately, I made my edits on the one that was.
well, that's
so
fine.
I'm trying to-
That's fine.
Yeah, I'm trying to go back and forth.
Only need to be in there one time. And if your goal of the initial,
It's not going to be in there just one time. And
Okay.
the language that's kind of at the bottom of the court's proposed RICO instruction right now, I mean, I'm thinking that it may be that there's sort of paragraph language for count one and then the 4 or 5 paragraphs after that, that's going to be after all of the instructions when, we always say, you'll have a verdict form. I think this verdict form may be one that I actually hand out to them and say, and walk them through. And then kind of say, all right, look, here's how you're going to think about this. And I am going to tell them when you're filling out the verdict form, because right now, at least, I'm thinking I'm going to have them list the overt acts that they unanimously agree to.
yeah, I think that would be best, Your
And
Honors.
that I'm going to say during that part, at least one of these, to support a conviction, at least one would need to be after May 10th, 2017.
Yeah, I think that would be the best way to go, and especially because of how, even for attorneys, how complex this is.
Yeah.
That if you could walk them through that form in that fashion, that would be beneficial for all involved.
Your Honor.
Yes.
As, just because this argument seems to have shifted a little bit, looking at the first page of the most recently distributed
Yes.
court's charges,
Mm-hmm.
simply adding after May 10, 2017 to number 6, each time you've got it, because you got it there twice. No,
Mhm.
any objection.
Okay.
That's fine.
All right.
Getting into the details of the statute of limitations as it may fit into the verdict form, I don't think you want to do that here.
I'm
because
not
it
going to.
Interrupts the flow of the elements.
Agreed.
And then when we get to the verdict form, I have a point about what's.
That would be
discussed.
great
I'll do
because
it- I can do it now, or I can do it.
Don't do
later
it
if you
now.
want.
don't do it now.
Okay, all right.
All right.
Not do it now.
Next.
All right. Under conspiracy, the last sentence, it may also be inferred from any evidence.
Where are you?
In last sentence. last
On the
full sentence.
state's proposed, where are
I'm
you?
Following this person.
Okay.
I'm-
I don't,
Okay, the charge begins with the bold.
yes.
The second paragraph under that, which. on-
Okay.
On my printout is the bottom.
Okay, yes.
All right, in the last line, it says after the commission of the alleged offense.
Yes, that is highlighted because that was the language that was proposed by somebody. And I don't know what that's supposed to mean. So what do y'all mean by that?
I don't know that this is what we proposed, but it.
I
may
don't
have
know
been-
where it
may
came
have been
from.
Picked up from language in other kinds of conspiracy cases. But I think here you could say, the alleged overt act as opposed to offense. Because some of them are offenses and some of them aren't.
I mean, I would imagine it was the state that proposed this.
It
I
may
mean, we
be,
could,
but I
just to be
understand
less
if-
confusing, just say presence, companionship, and conduct.
That's fine. And then we don't have to give it the temporal reference.
So. Well, I don't know, we need to say it at all, because we've already said the nature of any acts done, the relationships, which would be companionship, conduct of the alleged conspirators, which would be conduct.
And so
So
are you?
maybe
would-
just ditch that sentence altogether.
And stop at criminal design?
So it would read, the existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. Moving on?
If I could have just a second.
All right.
Um, Moving on, Your Honor.
Okay.
On second page, overt act.
Mhm.
um,
So obviously, I'm not going to include in there the two sources. I just wanted to let y'all know that's where I got the definition of overt act.
I understand, and I didn't think that was going to be in there. But the modifiers open or manifest,
Mm-hmm.
I don't think that's necessary. I think it tends to be confusing because they're going to be left to kind of guess at what open and manifest is. An overt act can actually be inaction.
We looked at the case law that y'all cited in support of that, and we don't read the case law to say that. It was supposedly in Pasha.
Pasha says that a single overt act is sufficient. Yes,
Doesn't say it can be a passive non-act act.
right. But
So where's that?
My main point is it doesn't say open or manifest. And I can't remember.
I'm trying to define overt act.
Right.
And there is a definition of overt act in the Bradford case. And maybe that was a conspiracy case, and that's why I cited 1648.
My only point here, Your Honor, is that I have never seen that language used in a Georgia RICO conspiracy.
Okay, well, do you have a definition of overt act? Because nobody knows what an overt act is. And to define overt act as an act in furtherance of the conspiracy doesn't define overt act.
guess
I mean, I'd love a definition.
All right, Your Honor, if we can have the opportunity to take a look at it, and we may be able to submit something that does that work. I'm just concerned about open or manifest. They aren't self-defining terms. I don't think they actually. lend a
If
lot
they
of
don't
clarity
help,
to it.
then yeah, I don't want to use them if they don't help.
I'll just, if you give us an opportunity.
Sure.
We'll look, and if we can find something that we think contributes to clarity, we'll certainly send it to the court promptly.
There's the Black's Law definition.
That's actually the place I was thinking. Generally, jury charges, I've looked at a lot of jury charges in connection with this and other cases, and I can't say that no court has ever used it. There's so many conspiracy cases out there. I'm just saying that I don't
Well,
remember
here's
any connection with
an
the
act that can be observed. I don't think it's flexible. Well,
I can't, I can't.
do you mind trying to get change the
Probably hasn't changed it since Blackstone. died.
correct?
Um,
All right, anyway, we'll come back to that.
Okay, also on page 2, the next modifying language naturally or necessarily done to further the unlawful enterprise. I think done to further the unlawful enterprise is sufficient. I'm not sure that naturally or necessarily adds.
Well, naturally might not, but I think something in the way of a modifier, because it's something that should not encompass, something conspirator X does that is it just this random thing that might, but is not designed, I think is and we didn't make that language up. It came from some case.
Okay, okay.
Sorry.
I understand. If it was just random, it wouldn't be done to further the enterprise. That's why I think done to further the enterprise captures what's necessary. I mean, the language in the statute is to effect the objectives of conspiracy. There's no naturally or necessarily. And
I think it might have even been from a U.S. Supreme Court case, but we'll ask Ms.
There's-
Persfield when she gets
there's,
back.
there's quite a few of those.
Any weigh-in from the defense on this?
I'm sorry, Your Honor. I have 3 different versions of very similar documents.
I am so sorry.
So,
I know.
It's okay. Mr., if you could tell me, I
I
gotta
can read it loud if that helps.
Well,
It's the bottom of page 2 of 5, the last paragraph in a document titled Judge Draft RICO Charge that we
They're all
received.
titled that, unfortunately.
I'm sorry?
I think
Oh, they're all
titled
labeled that. Rev 3, maybe it should have said.
It says when people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be the act of all of the conspirators. However, each conspirator is responsible to the extent that those acts are naturally or necessarily done to further the unlawful enterprise.
I'm not sure about the need for naturally, but I believe that necessarily is an important word there.
I'm going to disagree with that definition also.
We'll figure out the source of that language and come back to that as well.
May I go? I'm just going to try to jump in sequentially,
Okay.
so we can
Yeah.
go down this.
Yes,
one
yes,
next
that
bullet.
works.
If I could go to the paragraph above that.
Mm-hmm.
No, okay. 3 paragraphs above it,
To be an enterprise?
here,
What's it say?
here the specific enterprise the state alleges is Young Sod.
Oh, yeah.
I'm going to ask Your Honor to consider just taking that out. We're defining enterprise. I don't think it needs to make specific reference to the state's allegations.
Fine with me. I mean, they can read it in the indictment.
They read it in the indictment and we can argue it.
Okay. It's gone.
And then I'm gonna object, to, there's a paragraph, 2 paragraphs down from there, in determining whether an enterprise existed.
Yes.
I don't think we need anything after the racketeering activity, comma. I think it can say, in determining whether an enterprise exists, you may consider any evidence of a pattern of interrelated racketeering activity. Period, that's it. I don't think we need it, and such evidence may be sufficient for you to.
Yeah, that came from, I don't know,
Came from Turquette versus United States.
Yeah.
And Boyle versus United States. Straight out of Supreme Court language, and it's out of Martin versus State, which is Georgia Court of Appeals, adopting Turquette.
yeah,
Um,
it is confusing though.
Well.
I mean, it's like almost saying the same thing twice. I think the first time it's saying consider it, and then the second time it's saying it could be enough.
Yeah, I think you, to simplify it, if that's the objective, we might just say, determining whether an enterprise existed, you may consider any evidence of racketeering activity. Just stop there.
Oh, no, it needs to say a pattern of interrelated
Well, it
racketeering.
doesn't need to say a pattern and interrelated, so I can just say a pattern of racketeering activity, because when we defined it, it has to be interrelated.
And
Well,
if you-
then if that's the case, could we leave in interrelated and get rid of pattern? If you only want one of those words,
Sure.
I prefer
I'm
interrelated.
fine with both of them.
Well, I am too, and that's my preference.
This is, the concern I have, Your Honor, is we're drifting into the elements of 1614-4B and not C, because the state technically doesn't have to prove a pattern.
Well, it's not saying you do. It's saying you can consider any evidence that there might be.
I see. All right, fair enough.
Okay, in determining whether an enterprise existed, you may consider any evidence of a pattern of interrelated a pattern of racketeering activity.
I think just a pattern of racketeering activity, you're gonna define
Yeah.
the term
All right.
elsewhere.
We've got the Black's Law Dictionary now.
Drumroll.
We definitely act that indicates an intent to kill or seriously harm another person and thus gives a person a justification to use self-defense. That one is not applicable. Number 2, an outward act, however innocent in itself, done in furtherance of a conspiracy, treason, or criminal attempt. So an outward act, I mean, it's a, okay.
I think
See
outward
actus reus, also termed positive act.
is closer. Positive is easily
Open.
misconstrued.
Yeah.
by
Positive is
lawyers.
confusing.
I mean,
yeah.
I think the word manifest was like, it's something that's actually done, but whether that's a helpful word for the jury is another story. Let me just pull up Bradford real fast. All right, so this is Bradford v. State Supreme Court 285 Georgia 1 from 2009. An overt act is one commonly understood to be, quote, open, quote, manifest, or, quote, public, and that is citing Black's Law Dictionary. I think that's just the definition of, I don't know, it's a different Black's Law Dictionary than I have right now, but open, manifest, or public from Black's Law Dictionary 1990. Mine's probably newer than that.
Yeah, the most recent one is
Mine's not the most recent one. It's probably from law school, but
the best one.
It's the 7th edition, the one that I have.
Agreement that outward does the job. I think the fewer words that are used here, the better.
I think manifest can be confusing to a
Okay.
non-lawyer. So I,
I don't know what manifest
Means an outward act. Made in furtherance of a conspiracy. Thank you all for your help on that.
I don't know if we made it any better, Your Honor.
All right, now back to the naturally and necessarily. Ms. Percival, do you remember what case that language came from? The under enterprise, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally and necessarily done to further the unlawful enterprise. Okay, we'll get back to y'all. Mr. Floyd, it's from the jury instructions from the APS case, which you touted to be the standard by which we should all be
I
measured.
think I did.
So I think
mention
we're
that
gonna-
Things evolved a bit since then.
I think we'll be leaving that in there.
All right.
Thank you, Ms. Percival.
My plan is to not die on that hill. On page 3, Your Honor, definition of racketeering activity, the first line. I don't think or soliciting someone else.
Yeah, that's why it's
To
highlighted,
commit.
so that was where the teal
Yeah.
stuff got confusing. I didn't know whether the state wanted that in or
I think we can take it out.
So
What
it's
we were,
just
what we were
committing or
trying to
attempting
do
to
is
commit.
simplify it by not having you instruct on things that aren't.
Well, I don't believe there's any allegation or any evidence of solicitation of someone else.
Yeah, I don't either. Okay, so that would then just read, means committing or attempting to commit any of these crimes in the list. All right. Under the list, I think the states had use of an item with an altered identification mark. Do we have evidence of that?
Yes, Your Honor, it was the Trontavious Stevens had a firearm with a scratched off serial number
Okay.
that I think that evidence came in through an officer testifying about it.
I thought so. I just wanted to circle back on that one. And then all of your other teal things, again, I didn't know whether that meant
I
take
apologize.
these out, leave these in.
I apologize, Your Honor, for the teal confusion, but my intent was to, well,
Well, let me ask you this. If you look at the list as it exists in this draft, does that cover?
it does, Your Honor, and I actually, the burglary.
Right.
We do not need, that there was an
Okay.
allegation of a burglary on an overt act that we did not present evidence.
All
of.
right, we'll take that one out.
What about use of an item with an altered identification?
Yeah, we just talked about that one.
Okay, I'm sorry.
And Mr. Atkins is right. There was some evidence of that introduced.
Okay.
The possession or the use of?
The reason we put, let me explain that change. Okay, sorry. Is that some of the drug-related offenses are broader than mere possession or use. And so we put possession or use in there because that's possession and possession of with intent to distribute. That's what's charged.
Where are we talking about?
We are in the list
Mhm.
of crimes, the last two.
Okay. Possession of marijuana with intent to distribute and possession of marijuana?
Right.
Okay,
And I actually, we meant to make this modification with related to controlled substances, it may not have gotten in there. But the same thing, possession of controlled substances.
okay, so in violation of the Georgia Controlled Substances Act, do we want to
We can.
Article 2, and I assume that both codeine and cocaine are within Article 2 of,
That's
okay.
Schedule, cocaine's a Schedule 2, codeine's a Schedule 2 or 3. On memory.
So then it would be what? Possession of codeine with intent to distribute is what was charged, right?
Yes, it was, I don't, I mean, the language about Article 2, that comes from the actual language of the statute.
Right.
That's written for lawyers, that's not.
Right. No, I agree. I just, okay, possession of codeine with intent to distribute, possession of marijuana with intent to distribute,
Then we have
possession of
marijuana.
cocaine. And possession of marijuana. Okay. And then I still need, we're going to have the definition of murder anyway, and of the all of,
Mr. Atkins, can you submit that?
Yes, Your Honor. Yes,
okay,
Ms. Lyson.
all right.
I'm not the runner.
Okay, moving on to pattern of racketeering activity.
If I, you know, one
Yep.
other thing.
Sorry.
Based on your ruling, possession of marijuana could come out, your direct verdict argument, direct verdict ruling.
Nope. I'm sure the
I agree
defense
with
would be
Mr.
happy
Floyd.
to have it out.
I agree with
But-
Mr. Floyd, they can come out.
Yep.
To-
I think he misspoke on that.
Charges on the table, have this second paragraph with about the threats that I'm looking at.
Is it under racketeering activity or something
in-
else?
Well, I mean. Right, under we have racketeering activity.
Uh-huh.
And we define it, and then we have a second racketeering
Right.
activity also means any act or
Right.
threat.
Okay, I don't know. Do we have a threat that involves murder, robbery, theft, receiving stolen property, obstruction of justice, or dealing in narcotic or dangerous drugs?
We're gonna bring them homicide. Yes, for the caption of one of the photos. Yes, we do have, we have threats and we have acts.
Okay,
So, I mean, the any act or threat involving language comes directly out of the statute.
Okay, but we don't have a threat of robbery, theft. I don't know what it would be.
by God, I'm going to deal in narcotics.
We don't have a threat of obstruction of the officer. I don't know what a threat of receiving stolen property would be. So why don't we just say, and take what I would suggest, we just take that threat paragraph out and we could just put murder or threat of murder.
Well, and then you would have what? Any act involving for the.
Any
remaining-
act that involves murder, threat of murder, robbery, theft, et cetera, et cetera.
I think that could do it. yes.
Okay. Thank you.
Great with that thing.
Okay. I'm actually changing it online. What else? So that takes us to pattern of racketeering activity, although we definitely need the definition of the underlying crimes somewhere.
Your Honor, going back just a second,
Okay.
on the The reference to controlled substances on page 3, the two specific drugs would be cocaine and codeine, possession with intent to distribute.
Okay, so what I've done is just like we listed the specific other things, I've got possession of codeine with intent to distribute, possession of marijuana with intent to distribute, possession of cocaine, possession of marijuana. Does that work? Okay.
All right, thank you. Which would take us to page 5.
All right, are there any issues for the defense on pattern of racketeering activity?
Yes.
Okay. And I mean, I've even got an issue on what I list as my element number 3. When it's only a conspiracy, there don't have to have been racketeering acts achieved. There might be, but there don't have to be. And so how do we deal with they've got to be within 4 years of each other?
I don't think it's relevant here because the question is the contemplated objective, not the actual way it turned out, because that would be a substantive charge. I don't think there are any there aren't any that are separated by more than 4 years. as
Well,
guidance.
I mean, y'all were just arguing, we've got the murder of Donovan Thomas in 2015, murder of Mr. Drinks in 2022, right, which is more than 4 years. And so
Those two
assume
acts-
that's all that they find is interrelated. Then what?
Those would be the acts that actually occurred. Okay? And in a
Uh-huh.
substantive case, that would be an issue. Right? But this is where we get into this whole problem of exactly what was everybody contemplating every moment in time in a case like RICO that tends to unfold over
Mhm.
time. And so, Chamel, specifically Lyle Drink, had been in everybody's mind 4 years before. At some point, it came into
But if they contemplated,
killing opponents.
let's kill not just the leader, but the leader and everybody else we see,
Kill the cat and all the kittens as the.
then does it even matter? Does the 4 years not matter then?
4 years does not matter in that circumstance. And there's certainly no Georgia case that says it does.
Well, are there any Georgia cases that deal with conspiracy assertions and not substantive that also talk about this?
Provision?
Yes, to me, this is the toughest issue there is in terms of figuring out what the actual law to charge is.
I understand the challenge, Your Honor, but again, the one thing that when you look at the cases that address conspiracy is that while there are aspects of conspiracy and substantive charges that are similar and maybe even overlapping in some respects, conspiracy is different.
Yes.
And so what this is basically importing the what ultimately happened test in here. I'll go back to the hypothetical. And I'll try and.
Well, I mean, I understand your hypotheticals. What I'm going from is statute, further developed by case law.
I mean, the question is whether the conspiracy contemplates a pattern of racketeering activity. And if that pattern could take place within 4 years, I think that would be sufficient.
Right.
And we can't say that everything that actually happened had to fit that. 'Cause
But
that
how do we explain that?
changes it out of it. It's not a conspiracy case.
Now,
I mean, I don't think this needs to be mentioned to the jury, but if the court believes it does, the way to do it would be, I think, to say that they considered engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of, and not make this a separate thing at the end.
Well, so, Your Honor,
Mm-hmm.
on page 4 of, I think it's on both your drafts,
Mm-hmm.
you have an instruction, and I took liberty to propose some changes. So it might not be exactly how it is in your draft, but it says the state must prove, I added beyond a reasonable doubt.
Yeah.
that defendant-
I'm telling them that all of this is beyond a reasonable doubt. None of the pattern charges that have been changed say that every time. So,
Okay. And it says that defendant, and I took the liberty to say knowingly and willfully, agreed to join a conspiracy with
Are-
the knowledge
okay,
and
are we
intent.
back up at, I'm trying to figure out where I should go.
Mr. Short has jumped down to below the line of asterisks where it says
Okay.
for count 1.
Okay.
But I think that this charge may be what we're
Okay,
essentially
go
talking
ahead.
about.
I
The
just
state
wanted
must
to know
prove
where to.
the defendant,
Uh-huh.
I added knowingly and willfully,
Okay.
agreed to join the
Yeah,
con-
that
a
needs to be-
conspiracy.
With
with
the knowledge and
intent
intent
that-
is knowing and willingly, I think.
Okay. Yes. Your Honor. That one or more conspirators would commit at least 2 interrelated acts of racketeering. We're saying within 4 years of each other. And it seems like that charge would go to under where we're just previously talking. So
Okay.
we'd move that up. It seems to me.
And, Your Honor, I was not clear from this whether the section that begins on page 4 and is under the asterisks, whether this is something you were intending to speak to the jury about in connection with a verdict form, or whether this is part of the instruction.
Yeah, I don't know. I mean, it's part of the instruction. I think it needs to get said. Whether it gets said here or whether it gets said when I get to the verdict form, I hadn't decided yet. I just think this stuff needs to get said. So I don't know the answer.
Okay, and my own, here's my concern is
Yes.
that to the extent you're restating elements that
Yeah.
have been stated before, they're being restated in different language.
Right.
And that can be a source of confusion. I mean, the court, the way I was interpreting what the court did, as short and succinct and simple as you could, consistent with the language of the statute, and I understand that. But here, we're kind of restating the same premise, but with different words. I don't know which set of words the jury's going to follow. That's my.
I mean, as long as they're not inconsistent words, it doesn't matter. If they just further flesh something out, that's fine. So if you think they're inconsistent, point that out to me when we get there, preferably. But I don't think more words is worse. Frankly, most of this language is from some version of what the state wanted at some point. But I mean, I was kind of thinking it would be when we're talking about the verdict form, but yeah, I definitely don't want to be inconsistent. That would be bad and confusing. Don't want to confuse, want to clarify. Okay, so within 4 years of each other. So back to pattern of racketeering activity. I'm defining pattern of racketeering activity. Okay, but see, hang on. So we're defining pattern of racketeering activity, you need the concept that they have to be within 4 years of each other. And then they're not being found guilty of engaging in a pattern of racketeering activity if what they're supposed to be determining is, did they conspire to engage in a pattern of racketeering activity? But the jury still needs to understand what a pattern of racketeering activity is. So how about pattern of racketeering activity means 1, engaging in at least 2 acts of racketeering activity, 2, within 4 years of each other, 3, in furtherance of one or more interrelated incident schemes or transactions, and then explain what interrelated is.
I didn't need to speak over you. I think that is easier.
Okay.
It flows better.
Yeah,
It actually flows better than.
It
the
does.
statutory language.
yeah. Okay. All right, I think that's what we'll do then. So where does anybody have?
Interrelated, and
yeah.
this is not in the teal edits, but we're doing this quickly, and sometimes as I'm reading it through, I recognize this is not the biggest deal in the world, but I think interrelated might be easier if you said interrelated here means acts that have, and then you pick up that
Okay.
same or similar. Because interrelated modifies acts.
Okay. Yeah, that is definitely clearer.
With regard to criminal
Mm,
objectives,
Hang on.
sorry,
Interrelated here means acts that have
yes.
the same or similar blah, 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 or that are otherwise interrelated. Is that what you're proposing?
It is.
Okay, I think that works. All right, next.
Here, as far as criminal objectives, you pointed out that it's expressed in the indictment. There were some things that were not illegal, wouldn't automatically be illegal that be listed, and you taken 3 of them here.
Yeah.
We do not object to that.
Okay.
I think this encompasses also everything that was illegal in the other 2 categories, and therefore. Does the court plan to give them a copy of the instructions?
Oh, yeah. I always do, even in a one-day burglary case. Yeah. Not that we ever try those, but yes,
Yes, okay.
there's no reason it has to be a test of memory. I'm not, however, going to tell them that. Okay. All right. So now down to the kind of paragraphy language. My thought was that that would come not within these instructions, but at the very end when we get to the verdict form. But we still need to kind of walk through them and make sure that there's not anything that's incorrect or inconsistent that I'm saying. And Mr. Shart, you had mentioned, does the first one need to say, knowingly and willfully? And maybe I was thinking, and with the knowledge and intent would be the same, but it probably is safer to just say knowingly and willfully.
Or in lieu of.
Well,
I'm sorry, what's the proposed revision?
for count 1, the state must prove that the defendant knowingly and willfully agreed to join a conspiracy. And then I think it would maybe just say with the intent that one or more conspirators, himself and or a co-conspirator, would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to either get or keep money or other property or participate in the enterprise.
Okay, I don't object to that language, Your Honor. Thank you.
my only concern here, Your Honor, is that second state joining conspiracy.
I mean, if I don't say what the conspiracy is, or, I mean, we could join a conspiracy to,
I'm sorry.
do all sorts of things that wouldn't be RICO.
I understand. I think you're expecting me to say something I wasn't about to say.
Okay, sorry.
No, it's all right. I agreed to join a conspiracy, I think understanding,
Oh, instead of with the intent.
yes,
Yeah, understanding is much better.
or maybe
Thank
with the understanding that, either way. That way we're not giving them two intense standards in the same.
Understanding works.
Right. With that change, I don't think there's anything incorrect in that, and I don't think it's really inconsistent with what you said.
Okay.
It's just kind of a restatement. My concern is that we're getting the following paragraphs get into, I think, them determining, walking through the indictment and determining, are we unanimous on this one, are you unanimous on this one, et cetera, as opposed to what we were discussing yesterday, which is just telling them, you have to be unanimous that there was an overt act, and you have to be unanimous on which one it was. And you'll be telling them that it has to have come after a certain date. So that covers everything. This is frankly, part of my worry here is that we get a jury who goes in with a very, very long form, they get tired, they go through, they check off a few, and then they say, well, that's good enough, she said we only needed one. And this only works if they go through the entire thing.
I mean, I'm not listing all of them on the verdict form, if that's what you mean.
Then I misunderstood. I was afraid that that's what it.
So what I was thinking about doing was saying like, I don't know yet, but defendant X did not join whatever this conspiracy is. If it's did not, that's the end of count one. If it's did, then potentially these are the interrelated types or acts of racketeering activity, or this is the pattern of racketeering activity, and have them listed.
But then now we've turned it into a substantive case, not a conspiracy case. That's my concern.
No, but there
This
was-
is the pattern that they agreed to. You must then determine which interrelated types or acts of racketeering activity the defendant agreed would be committed.
Well, I don't,
They agreed that they would murder everybody, or whatever they might come up with.
I see, I think I understand what you're is looking at. Problem is types or acts. I mean, are you contemplating that they basically have a menu and they check it off?
No.
And the menu is acts of violence, narcotics, property crimes. I mean, that.
I mean,
might-
I was gonna get input from y'all. I don't know.
Well, that might work. I mean, my concern when I read this was I thought we were back to the point where we were looking at a list that just tracked every overt act in the indictment. And I can see a lot of reasons why that could cause problems.
So it could either be, you must unanimously determine which interrelated types or acts, that one's still up for debate, of racketeering activity the defendant agreed would be committed, and then have them listed, or that interrelated types of racketeering activity would the defendant.
I think all they have to decide is that they contemplated committing interrelated acts of racketeering activity.
Well, they agreed to, not they contemplated it. You could contemplate it and reject it.
Fair enough. Okay. But that's really the question before the jury is, did the agreement contemplate what would ultimately have become a substantive violation? I'm very concerned about using the word acts because you can see how they could get all hung up on that. And that's not really what the conspiracy law requires the jury to determine is the specific acts. That's what we talked about yesterday. The federal cases I cited to you, they all say they don't have to determine which specific acts were contemplated, only the types.
But even those federal cases say that the jury has to be unanimous on the types of acts that were committed. You'd agree with that, correct?
Whatever the jury's deciding, they have to be unanimous. I agree with that.
And
All right,
unanimous on the types of
Don't
acts.
talk to each other. Got to
I'm sorry.
talk through me. That's just how it works in court. You know that. I know you didn't mean anything by it, but
I
it
always enjoy
sometimes
discussions.
devolves. I don't think it would with this particular crowd we have right now, but
Anyway, Your Honor,
yes.
I believe that the federal cases that Mr. Floyd cites would require the jury to be unanimous
Yeah.
in the types of racketeering activity, and I think it would be necessary for them to indicate which are the types on their verdict form.
I don't think it's required.
Well,
just trying to
shall we
figure
say
out-
helpful? I'm trying to also contemplate if there is, as Mr. Steele might say, God forbid, a guilty verdict in this case, and an appellate court is reviewing, I think without some tiny level of, I even hesitate to call this detail because it's so high level, but some guidance on the basis for the jury's verdict, that it would be difficult to review. And also, we would want to ensure that they are unanimous on the type. So if they indicate the type, that would ensure that.
Here's my issue with type. I mean, so let's say they don't decide, or the jury doesn't think, oh, they decided they would murder all. Let's say they think they decided, we're just going to hassle Lucci in any way possible. So we're going to steal things from Lucci. We're going to stab Lucci's mama. We're going to do X, Y, and Z. Those are different types of racketeering activity with the same victim. So it doesn't have to be the same type. And
That's correct.
so that's the wrong word to say.
And it's the one that crept into the case law, but I think.
Yeah,
the observation is
it's
correct.
wrong.
But
And I'm sorry, I'm kind of like thinking through this as we do this
Yeah,
because
that-
I've never done a RICO case before as a judge.
And I've never done one that didn't have a new issue pop up that I never thought
Right.
of before.
But
but as Mr. Floyd says, that is the language, as unfortunate as it may be.
well, I'm not going
in
to, I
the
don't care
case
if
law.
language is in a case. If it's wrong as law, I'm not going to use it.
Your Honor, to follow up on the point you just made, what
It's-
in this case,
Yeah.
what we are really talking about with this enterprise, with this criminal street gang, is an open-ended conspiracy because they're going to do what they decide to do. And once you're in, you're basically agreeing
Mhm.
to do. As long as these are things that such an organization might accomplish when you sign up for it. And this is what, when you look at the older U.S. Supreme Court cases, one that sort of states the bedrock principles, like Pinkerton, for example, basically says, you sign up in a criminal endeavor, you're on the hook for whatever follows from that. The solution to that is not to sign up for it, is not to become joined into it. And in a gang like this, an organization like this, the sort of one of the fundamental tenets is acts of violence and threats of violence against perceive as your opposition or competition. That's the real question is, are you agreeing to join in an organization that does those things?
But it's
And that you or somebody in that organization would do them.
Well, right, yes, but that's my point.
Well, I
is
mean, that's the
within
rub.
That's within the contemplation. I mean, when you're joining up, those things have already happened. You already know this is what this organization does. It's not like you joined the Boy Scouts and you found out that they are engaged in acts of terrorism. It's like joining a terrorist organization and finding out they're engaged in acts of terrorism. This language that we have here is getting at the point, which is, do they contemplate interrelated acts of racketeering activity will occur?
and we do.
And I guess we've already said it up above. If we're not going to say what was it, then we've said the state must prove the defendant knowingly and willfully agreed to join a conspiracy, understanding that one of them would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to purposes.
And
But-
in Georgia law, with the statutory definition, we pick up the same types in there. I mean, it's kind of baked into the definition that you've already got in the instructions.
But we're in a situation that happened in these federal cases where there was an argument you shouldn't have to find specific acts. And I think that's why the federal courts have gone to, okay, fine, you don't want us to look at these. I guess they went one level up to types of acts that occurred.
Well,
But was that a conspiracy case?
to be
I mean,
Uh,
as long as I'm saying you have to be, I'm sorry, that you have to be unanimous that they proved all these things.
Go ahead,
I don't
Mr.
mean to
Floyd.
interrupt you. To be clear, the cases that I was talking about yesterday, those aren't verdict form cases. That's where the request was that the jury be asked to fill out a form that went through every single one of them. And they said no, and the jury was instructed on types, not that the jury filled out a form on types. We don't want to get, I don't want us to back into giving them an essay question. That's not what we ask juries to do. Juries say yes, no. And if we kind of open it up for them to express themselves, I think we're asking for trouble. There's a good reason why.
I'm sorry, I'm not requesting an essay from the jury. It is the type of activity that they have found, or, I mean, it's not my preferred outcome, but some form of check the box, as the state may have indicated, perhaps just some guidance more than yes or no. And I appreciate that that's what the state would prefer.
Your Honor,
Yeah.
I have an idea. We're all thinking out loud here a little bit. What if it is contemplated the commission of 2 or more related acts of racketeering activity in furtherance of one of the criminal objectives of the conspiracy? Because that would actually tie in to something concrete that you're already doing.
Contemplate.
Should say that again.
Agreed to join a conspiracy, understanding that one or more conspirators, himself and or a co-conspirator, would commit at least 2 interrelated acts of racketeering activity to achieve one or more of the criminal objectives of the conspiracy. The reason I say that is you're telling them what those objectives are, and those objectives encompass the substantive violation.
And is that a recommendation regarding the second to last paragraph on page 4?
Yes,
Could I ask what that proposed language is again?
memory test.
To achieve
Well, that's-
one or more of the criminal objectives of the conspiracy. Right?
Yes.
But where are you saying to put that?
Where you have 1 and 2,
Yeah,
instead of sub 1 and 2, either you just say acts, racketeering activity to achieve one or more of the objectives of the criminal conspiracy.
okay, so.
And the reason I say that, here contemplate the violations of A and B.
But how do I know? Does it even matter? Do I need to know which one they
Done
return?
because of Cotton 2.
Well, I don't know what that shorthand force or what does Cotman 2 say?
Cotton 2 said it is sufficient to prove either or both of the A or
But I don't need to know.
conspiracy to violate either or both of A or B.
Okay, well, I know that. But I don't need to know which one or ones they.
Exactly the
Okay.
question.
The jury's decision as opaque as possible.
Well, I'm obviously not trying to do that.
I didn't want to imply that the court.
See, that leaves one person.
Well, I'm not allowed to directly address you, Mr. Floyd, which,
So, can I,
Yeah.
so we were talking about, back up to that paragraph, the second to last one. And Mr. Floyd, if you could just help me follow your train of thought, does that affect what you're proposing in this second to last paragraph, does that affect the last paragraph on that page? That Mr. Floyd is trying to incorporate into the second to last paragraph, but it's still leaving certain aspects of the last paragraph out.
Well, I understand.
I'm trying, is the state suggesting removing the last paragraph?
That's what I just said. I think it obviates the need.
Oh.
And remember that as we're discussing this, Your Honor, this all is coming after you have instructed the jury.
That they do have to unanimously find which types of interrelated racketeering activity occurred. That must be unanimous.
Well, they have to
Yeah.
unanimously find that defendant joined the conspiracy, and then
Yeah.
also determine what.
Right.
And Your Honor.
All right, I'm satisfied that they don't have to list out what pattern of racketeering activity they think anybody may have conspired to commit. As long as they unanimously agree that a defendant conspired to commit a pattern of interrelated racketeering activity. Is there any case law that they have to list it out? If it's a conspiracy case and not substantive?
First, I'll divide my answer into two parts. Part one, Georgia, no. Part two, I'm not aware of any other jurisdiction that requires it, but certainly not in Georgia.
But, Your Honor, this is my
Yeah.
understanding. It's not just that they have to, and with the intent of a pattern of racketeering activity, they have to unanimously agree on,
What it,
right, which,
what it is.
right.
Mhm.
Like if some of them say, oh, he was joined for
Right.
theft, and the other,
Right, okay.
And Your Honor, I think my suggestion contemplates this, because by referring back to the criminal objectives, stated what those are. They only have to find that two or more types of criminal conduct.
Mm-mm. Objectives and pattern of racketeering activity are not the same element.
I understand, but each of these says through acts of racketeering activity and then lists crimes. It doesn't just stop at objective. It says you're going to achieve this objective by committing these crimes.
So you're saying that if they find any of those, that any of it was done, a count of murder and a count or an act of murder and an act of a threat of violence were what was contemplated, that would necessarily, because they would have had to determine which is preserving, enhancing, protecting, blah, 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 which is a same or similar intent or result.
With the exception of the blah, blah, blah part, you said it better than I did.
Okay.
Yeah. I mean, I think it's already captured there.
Yeah. Thoughts?
we've been moving around a lot. Could I just hear the final proposal?
Is, Mr. Floyd's is that in that first paragraph, that instead of saying to either one or two, that it would just say within 4 years of each other to achieve a criminal objective of the conspiracy.
I understand that part, and I'm not.
I haven't
opposed-
gotten past that part yet, too. I'm trying to figure out, how do I am at the point where, okay, that paragraph says everybody has to agree that they agreed to commit interrelated racketeering, a pattern of racketeering activity. But if they have to unanimously agree then I need to at least tell them that.
Is there any disagreement among the parties that they do have to unanimously agree?
I don't think so. Everybody agrees about that, right?
Unanimously agree with what?
About what pattern of racketeering activity they agreed would be committed.
And state's view of this is that if it is, they had to agree to commit this act, that act, that act. I think we've passed that.
That's not what they're asking about.
And so when we
Hang on,
get-
hang on.
Sorry.
Does the state agree that there needs to be a unanimous determination as to what pattern of activity, racketeering activity, was contemplated as being carried out? Whether it ever,
I don't believe the statute requires that.
I,
And if I can just finish.
yeah, I'm sorry.
The conspiracy has to contemplate the pattern.
yes.
Yes, right. Does the conspiracy have to contemplate specific
That's,
crimes?
I'm sorry, that's not what I mean.
I understand. I'm just,
Okay.
I'm trying to walk through the hierarchy. Does the conspiracy have to contemplate specific categories of crimes? No, all it has to do is contemplate that the crimes will be related to each other.
Right.
Because that's what would form a pattern.
Okay.
But do they have to be unanimous in their determination of whether they tell us what it was or not, of what that pattern was? I'm sorry to I mean, this is probably really painful for everybody,
No,
but
and I
we
don't
need
mean
to
to
get it
interrupt.
right.
I don't mean to interrupt anyone. I'm just looking at a case from the 10th Circuit, US v. Randall. I'll give you the site in just a moment, but I'm sure the state knows it. And I'm reading where they're trying to decide what circuits to align with. And they state further, we now join the circuits discussed above in concluding that for a charge of RICO conspiracy, and this is as the state says, a jury need only be unanimous. Well, they don't say this. A jury need only be unanimous as to the types of predicate racketeering acts that the defendant agreed to commit, not to the specific predicate acts themselves. And that's where I thought that we were in agreement with the state, that there needs to be unanimity. And I know you don't like the word types, and that's their language, not mine, Your Honor. But there needs to be unanimity, and let's call it the pattern of the predicate racketeering activity. And that's the 10th Circuit, and I believe they're agreeing with a number of other circuits.
Okay, so how about if we just say, would this work? Is this correct and sufficient? You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed.
That's acceptable to Mr. Kendrick.
Could you say one more time?
Sure. You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be permitted.
Committed.
Commented.
Okay.
Because I think the jury is going to read that as they had to agree to commit specific acts. I know that's not what you're intending to instruct them, but I'm afraid that's what they're going to hear, and that's what the argument we're going to get,
Then we
which
can
would be
say
contrary to the law.
you do not have to be unanimous about specific ... only You know, I mean, let's just nip it
Unanimous.
in the bud. Just tell them.
That would be great,
Only unanimous in the pattern.
that there would be a pattern.
Oh, we're so close.
And what the pattern is, really.
Right.
A specific that.
Yeah.
Well, the word specific just is another way to.
We
back
won't,
into
we
the
won't
same
say
problem.
specific, unanimous. I mean, I just said it, so I'm not going to say it again. You do not. You do not have to be unanimous. Specific acts, as to specific acts, what?
You do not need to be unanimous as to any individual acts.
Individual I worry about, because most
As
people think
to.
of individual, they think of a person.
Single act.
I like specific.
You do not need to be unanimous as to specific acts.
I think that's accurate.
Can you read it back as a whole, Your
Sure.
Honor?
You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts.
Are you gonna say that after joined such a conspiracy? And then say what you said. I'm just going by the last paragraph, page 4.
I mean, I don't even know where that language went. The first paragraph. Then what did I say? If you,
You mean, what did you previously have in this
Yes.
document? The
Uh-huh.
document originally read, the one sent to us at lunch after that paragraph. If you unanimously determine that defendant joined a such conspiracy, comma, you must then determine which interrelated types, with the S in parentheses, or acts of racketeering activity the defendant agreed would be
okay,
committed.
no, I don't think I'm going to say that anymore. I think because I am saying the state has to prove they, agreed to join a conspiracy, understanding that somebody was going to commit at least 2 interrelated acts of racketeering activity. And within 4 years of each other, to either get or keep money or participate in the enterprise or to achieve a criminal objective of the conspiracy. I think maybe then right there, just put in parentheticals, quote, pattern of racketeering activity.
Did we lose your?
But then there was the language.
I know, I hadn't gotten to it yet. I'm sorry. Sorry. I think I would then just say you must be unanimous in your determination as to the pattern of activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts. I don't know.
That's acceptable to Mr. Kendrick.
Okay.
Could we get a brief break at this point?
Yes.
Your Honor, obviously, I'd like to look at the final words, but I think, in principle, I think you've got it.
All right. Yeah, let's take a quick break.
Thank you.
All right, are we, enough of us back that we can dive back in? I think I may have come up with a way to say this. So we had talked about in that kind of first paragraph, whether to say that either, money or property or participate, or instead to say to further a criminal objective. Was everybody in agreement about that or no?
Are we on page 4, Your Honor?
Yes.
Is there any way possible to throw that up on the monitor?
Yes, I could screen share. I could join Zoom and screen share.
That would be very beneficial.
What a great
for me.
idea. Okay,
Thank you.
bless you. I think I'm in Zoom already.
Thank you, Miss.
I'm not usually the one sharing, so. A moment, I've got it. I just have got a lot of things open, so I think it's this one. Is that the right one? Okay.
Oh, that's very helpful. Thank you.
We should have maybe been doing that the whole time. All right, so one thing I've thought about is just kind of lead in, hey, y'all, your verdict as to every count needs to be unanimous. That means you need to be unanimous in your determination that the state has proven every element of that count beyond a reasonable doubt. For count 1, here's what the state has to prove. And I've put all of it in there. And I don't know whether we want to say to achieve a criminal objective or the one or the other. We can decide, but I'm going to say all of it. They have to prove all of this, and then they also have to prove, an overt act. To be unanimous on this count, you must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. You do not have to be unanimous as to specific acts. You must also be unanimous as to any overt act or acts committed to further a criminal objective of the conspiracy. And then whether we want, again, the reminder that it has to be after May 10th, whatever. And then as long as they're unanimous on an overt act, do they have to list the overt act? Or do I just, it's kind of the same question again.
State's position do not. They do need to be unanimous. There was one, and which one it was, but they don't have to list it. They only have to be unanimous as to one.
Your Honor,
Yes.
for the record, I am objecting to that you do not have to be unanimous as to specific acts.
Okay.
However, having said that, if Your Honor is going to include that, to me, the last sentence that Mr. Floyd is objecting to doesn't make a lot of sense, because we're telling them they don't have to be unanimous, and then
That's what I'm asking. Do they still have to?
right. If we're going to keep in that that you do not have to be unanimous as specific acts,
It's confusing
as a juror, it wouldn't make much
to
sense.
then say you have to unanimous about an overt act.
Those are different. One is,
I know, but are they going to know the difference? Acts of racketeering activity. Maybe that's the way to clear that up.
Okay.
Would that work better?
I think it would.
Okay.
and then I understand the state does not want the overt act on the verdict form. The defense would want or at least Mr. Kendrick would want that on the verdict form.
I would.
Which one it is?
The one that says you should note on your verdict form any overt acts in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. I would like to see that on the verdict form just to ensure that they did pick one within the proper time frame.
Okay.
And I'm not sure how council contemplate that this would actually happen. Would they list a number or
They'd write out, I don't know. I mean,
they?
I guess if it was an act in the listed out, they could just list the overt act number.
And I think, all right, this is why I'm asking, Your Honor, because they could also find an overt act that isn't listed out.
Thank for
Yeah.
that.
I mean, I'm serious, like, literally
So am
to
I.
say, and, you know, you can list them by number, or you can list an act, anything else that you determine is an overt act, and they can go ahead and do that. I'm trying to think of physically how this happens without them. And I'm not, to be clear, I'm not saying the state doesn't object to that. I'm just trying to figure out what it is we're talking about before I address it.
How about that?
And Your Honor, if you could scroll up toward that long paragraph in the
That
middle
what
of
that
page
means?
4, there where it says for count 1. I think that's as concise as you can possibly make it, but I'm wondering, given that it's such a complicated paragraph, if it might benefit just from a formatting perspective, if you broke it up the same way you did on page 1, where the different
Okay.
elements are on different lines.
For one thing, we need to decide, is it going to be are we going to say or are we going to say, well, that did not help at all. Which of those two things are we going to say? There.
But yeah, I'm just studying for a moment.
So the orange is what Mr. Floyd had proposed. The blue is what I had originally. And we could have the i.e. a pattern of racketeering activity that actually doesn't go there, that goes up there. Oh, no, it doesn't, because it has to be to achieve a criminal objective of the conspiracy.
I agree with that. Yeah. I think the get or keep money or other property and participate in enterprise is wrapped up in the statement of the criminal objective, which you've given them before.
Yeah, I know you think that.
Yeah.
So thank you. What does the defense think? And actually, Mr. Floyd, do you think that this survives appellate review as giving them the correct instruction?
Your Honor, I may be right, I may be wrong, but that question is forefront in my mind in everything I'm saying.
Okay.
part of that is the appellate analysis, which is and this is why I've been referencing where you've said things in other places, that you know better than I do, the jury instructions are read as a whole. And
I
think
know.
that encompass, given what these instructions have elsewhere, that gives me gives me a good deal of comfort.
Your Honor,
Mm-hmm.
my preference is more for the original language with the caveat that might actually go against me is that I'm just not entirely clear what participate in the enterprise means.
Yeah, me either, but that's the way the statute. It's, Mr. Floyd's might be more elegant, but the original tracks the statute, and we're less likely to commit error by tracking the language of the statute. Because if you go way up above to what the elements are, one of the elements for Part B is participate in the enterprise through a pattern of racketeering activity.
Right, yeah. Obviously, I can't challenge that, Your Honor. I was looking at in the language that I was suggesting, I was looking at number 7, we list the elements, which references the criminal objective. So circling back to that, I'm trying to be consistent in the language.
I mean, the other way we could say it would to join a conspiracy, understanding that, no, it's just too awkward. I'm trying to flip like the order of them, that they would get or keep money or participate in the enterprise through, but I'm not going to do it that way. All right, it's just going to stay like that.
And then drop a comma after the 2017.
Oh, yeah, we're just going to have to agree to disagree on that because I'm sorry, but I don't like to offset the year with 2 commas. Sorry.
Do you use an Oxford comma?
Oh, absolutely.
Okay, well, we can agree on that. then.
Okay, yeah. All right. And so then they're being told they have to be unanimous about the pattern of racketeering activity, but not specific acts of racketeering activity. They need to be unanimous that at least one overt act was committed in that time frame. And then they're going to list on the verdict form whatever acts they unanimously find. And then it's going to be, you can list them out by act number or write out what you find.
Last sentence. I don't think it's necessary. I understand that you disagree with me. And I'm just observing that.
I don't know if it's necessary, but it's not error to do it. Is it? Okay.
That language itself, I'm not certain that it's error, Your Honor. The question is really, this is one of those devil in the details things, which is to be exactly what that verdict form says when you embody that language.
Well, I've invited people to submit proposed verdict forms. So now that we know what the charge is going to be, I would continue to welcome that.
I understand, and we will modify our proposed verdict form because now we have a better idea of what the charge is
Okay.
going to be. Thank you.
And I'm sorry, it's just not an easy thing to do. Okay, so I shall stop screen sharing for now. All right, we need to circle back to a couple of items that were on and I don't mind if it would be helpful to share this one as well. Was that helpful?
Very helpful. Thank
Okay.
you.
Is it the version that was sent last night? It should be, yes.
Yes, I haven't done anything to it. So I'm just going to scroll through unless anybody's thought of anything else to where we had noted we needed to. All right, the stipulations.
We're working on that as we speak.
Go back up to the beginning and take out the counts on which a directed verdict was granted, which were counts. $59. Laura, can you take that for action? Because I don't know how to get rid of the. Thank you. 59, 60, and 62 are out.
Yes, you're right.
And then
I don't know if that's changing on both figures. Is it?
63 is not gone completely. It's just different now.
Now it's a 131 instead of a 133,
Right.
correct?
Maybe we take off the language. He was convicted of a felony, we just say possession of a firearm by convicted felon.
Right. Right. Just ditch the previously convicted of a felony part. It would just be possession of a firearm by a convicted felon, 131. And we'll just have to explain to them something, I don't know what. All right, so then from Mr. Stillwell, 52 and 64 change. All right. Y'all are still working on the stipulations. And the stipulations, once you write them up, they can just go out with, or is that what they're going to do? I mean, in which case, if they're going out, I can just kind of generally say about these topics instead of reading them, or I can read them, whichever. So, I mean, normally it's like a piece of paper that's, joint exhibit, whatever it is. I don't know if y'all have done any more joint exhibits, but
So maybe we just make reference to the joint exhibit first.
yeah. Okay. Have entered into, the parties have entered into stipulation facts. And then,
I think there's 4 separate stipulations. So I don't know if we're gonna make it each number.
these,
Is that correct, 4?
bad typing, but we can fix that later. These 4 stipulations be are marked as joint exhibits. We can make it pretty later. Okay. Oh. mm. Really bad typing. Maybe I shouldn't type while it's on the screen. And then where the parties stipulate it's in the nature of evidence. All right. Apparently down on 13140, there was a question as to whether you were going to check, Ms. Hilton, on whether any of the criminal convictions were for a crime of dishonesty or making a false statement. Okay, well, at this point, we're just going to say felony. Okay. I don't know why this is highlighted.
Because I objected to it,
Okay.
but it's pattern, so I understand.
I've got a question. I mean, yes, a conspirator is an accomplice, but do we need to use both of those words here when we're saying where the witness is an accomplice? It wouldn't hurt to say or co-conspirator. Thoughts, anyone? Tell them, here's how you can, okay, I'll just leave it the way it is if nobody has any preference.
Actually, I'm sorry. I think it's a good idea to put or Coke.
Anybody care whether we say on its own or by itself?
No.
We'll just go back, and I'm not going to do this right now, but we'll just say or co-conspirator for all of those. Can do that. All right.
Your Honor?
Mm-hmm.
I could be mistaken, but the only concern with the accomplice
Mm-hmm.
or co-conspirator is that corroboration of an accomplice instruction with it, if it's truly a co-conspirator, it's not
You're
that same
right.
legal principle,
You're right.
I assume, thank you, Your Honor.
All right. And we're instructing them separately about. All right, and the defendants have both chosen not to testify, so we now know that. Any ideas? Coming back to here, y'all.
That's what I'm trying to figure
So
out.
I think on the one above, we were trying to determine if that was appropriate, because did we really have a photo lineup type scenario where that would apply? I don't. And I think we were adding accomplices to the one below because we were trying to think through, there were no photo
Mhm.
lineups. Type scenarios involving Mr. Kendrick.
Yeah, there's no identification really of each.
Was to certain overt acts
Mhm.
that were not these gentlemen, specifically Mr. Demise McMullen, Mr. Walter Murphy, a shooting case.
Right.
I remember that, and there's probably
Okay.
others. So we were trying to figure out how, if you look at 135.
Well, yeah, and it's not even just lineups. I mean, it's like the girl who was in the car that identified Ryan as the one who killed.
And so I think that probably needs to stay in there. So I think in 13511, what we were struggling with is it's written.
Yeah.
Defendants.
Yeah. Right. So,
Can we, I don't love the conspirator because it's almost, I know it's not intended this way, but it's almost like a suggestion that Ryan is a conspirator with us. Rather than put a label on it.
Your Honor,
yeah.
the only, I'm thinking through in terms of, if it's not in regards to a defendant, the beyond a reasonable doubt, like
Uh-huh.
the germane issue of this is, you know, how a jury's gonna.
Right.
Pretty
Yep.
significant identification of the
Yeah.
defendant in a crime.
Well, except that when we're dealing with the overt acts, even with Mr. Ryan, beyond a reasonable doubt. So I don't think the standard is any different.
No idea as the perpetrator of, I mean, it's not necessarily crimes that anybody's charged with if they're overt acts.
Here are the acts.
Yes.
And then not the party, right?
Correct.
Party. The perpetrator of or party to the act.
Or act/crime, whatever.
Well, act is broader. No means
Ugh.
slash crime.
The act slash crime?
No, just
The
act.
act. Do y'all want a defendant show
That the individual.
that another person committed any alleged offense? This part's weird because of our overt acts.
If another person committed the alleged act. Perpetrated the alleged act.
That okay with the state? Just change offense to act?
Yes, Your Honor.
Okay. And then I guess we're fine with that. I mean, if we're gonna say this part, I mean, I don't know that we need to say this part at all right now.
Or maybe prove the problem is, these are written for the quote unquote defendant.
Yeah.
but Theoretically, we are, myself and Mr. Weinstein and our clients are potentially defending not only our clients, but other individuals as
Right.
well. But the burden of proof doesn't rest with us, so
Right.
it rests with the state. So I think that's an appropriate, I would just, maybe I would just go back to the more inclusive individual.
But they don't have to prove a specific individual. I mean, they could prove some unindicted co-conspirator committed one of the overt acts. And so by definition, we might not know who they are. I mean, it says up here beyond a reasonable doubt. I think the rest of this, because it's written for something that's totally not applicable here, maybe just is confusing and also not necessary. What do you think?
The state agrees that the remaining two paragraphs are not needed, Your Honor, for the purposes just outlined by the court.
But it seems that the last paragraph would apply when we're speaking about actually, I don't know what to do with that.
I do.
Could we add on the end of that paragraph that remains, like the burden of proving.
The burden never shifts to the defense.
Or the burden of proving identification. The state bears the burden of proving.
What?
See, that's what you do in the last paragraph.
The state has the burden or bears the burden of proving identification beyond reasonable doubt. Well, we already have the beyond reasonable doubt. Is that in the beyond
No.
reasonable doubt?
How about just the burden of proof never shifts to the defense?
That sounds fine.
The state agrees, Your Honor.
All right. All right, I'm going to give that, so we're going to unhighlight that. Knowledge. So some of these come out. Yeah. I'm going to say a firearm here. Yeah, but damn it.
Yes. Your Honor, before we get too far, the only thought with the knowledge piece, of course, the court outlines the crimes provided. The state just wanted to make sure and was thinking, out of an abundance of caution for the jury to understand that, RICO is not what, this paragraph is envisioning in terms of that knowledge requirement. I mean, the court or the state was thinking through out loud if, this of knowledge doesn't fit the, the RICO instructions are kind of in their own universe.
Well, that's why it doesn't, I'm sorry. But you
And-
give a set list.
Yes, Your Honor, or this instruction is limited to these, counts or.
It sufficiently says this doesn't include RICO.
Thank you, Your Honor.
Okay, appreciate you bringing that up. Okay. All right, I'm saying this before the RICO also, but I don't think it hurts to say this one. Is this multiple ways of committing a crime only applicable to RICO? All right, Laura, do you want to just delete all of the RICO stuff and drop what we just did into there?
Your Honor, in answer to your question about more than one way,
Mhm.
that there are gang act charges here which allege more than
Okay.
one type of criminal street gang activity in as the, I hate to use the term, the predicate or foundation for the criminal street gang violation. So we
Okay.
have that issue there too.
All right, so I'll just kind of say that in here in the midst of it, and then I'll say it again before I'm talking about RICO. Okay, criminal gang activity. Counts 50 and 57. This one may have to be separated out for each.
I'm not,
Or we could
without
put-
looking at the statute, I don't know the term of art, but I think it's criminal gang activity. And
Yeah.
And then I think we could just put, the following offenses
Where did
would
it go?
constitute, if proven, would constitute criminal gang activity.
I have no idea where that,
But count 57 is pretty specific as to what are the actions.
I can't. What was somebody saying?
Well, you had the blanket, it looked like you were looking, I was interpreting that as you were gonna add a specific offense. And I was thinking you would just put criminal gang activity, as defined.
I mean,
And then we define criminal game. It's defined, I think, above, but
it's not. Oh, yeah.
Your Honor, in that
Yeah.
paragraph where it has criminal gang activity, I believe there needs to be possession of either marijuana with intent to distribute, because it has any criminal offense that involves violence, possession of a weapon, or use of a weapon. So there
Yeah.
may be, needs to be a comma. Marijuana with intent to distribute, because that's not defined in the first criminal gang activity. But it is.
We don't have use of a weapon alleged, right? Oh, yes, we do. Never mind. Never mind.
You have it defined below, but not in the first criminal gang activity paragraph
So possession of marijuana,
with intent to distribute.
does it have to be with? Okay.
That's the only charge left. Yes, Your Honor.
So I think. Why is that
But
not highlighted?
don't, I'm trying to understand, Your Honors, down here below where you have 50 and 57 lumped together.
Because that's subsection A. Subsection B, maintain or increase his status or position, which your client is not charged with.
No, but here's what I'm trying to understand, and I need the court's help. In the indictment for count 57, if you look at that
Yes.
count, and again, I'm not really arguing, I'm just kind of hoping for some enlightenment.
Okay.
The street gang activity under A is, the offenses are specifically listed: possession of marijuana with intent to distribute, and then the codeine and the cocaine, which have been thrown out,
Right.
and then possession of firearm during commission of felony. So shouldn't, for a conviction under 57, one of those two things need to be found?
Yes, which is what the blanks would be.
Yeah, but that would apply to 57. Isn't it different for Mr. Stillwell in 51?
Yes. Yes.
Oh, I'm sorry. Oh, okay. I
It's
understand
okay.
now.
I mean, so it may be that right here, we just say criminal street gang or whatever it is, criminal gang activity. And then below, what typically happens then would be, can somebody look up never mind, I've got it right in front of me. No, it's 5.3 that lists what the gang activity is, right? Yes, Mr. Sharp.
So I would suggest we just put in criminal gang activity, and then we have the definition of criminal street gang. And below that, because we're just kind of going, I'm thinking sequentially by the elements. Below that, we define what you're about to talk about right now, criminal gang activity. And then we bring that paragraph that was just above all these elements,
Mhm.
drop it down to there.
So you're saying move the criminal gang activity paragraph down?
Down, because it's like we're giving the definition before we give the elements. So we give the
Okay.
elements, and then we follow with the
Mhm.
definitions.
Where in 1615.3 is anything about drugs? Is it just because it would also be an offensive racketeering activity?
Yes.
Okay. All right. Okay, so these would both say criminal gang activity, right? is so painful. Oh, where's paste? And then take this and move it down below. Is that what you're saying? That makes so much more sense. Thank you. Do criminal street gang, and then we'll do criminal gang activity. Right.
That criminal being activity below, because we'll get there.
What?
I have a feeling, as we scroll down, we have criminal gang activity. Right, so we kind
Ah.
of said the same thing twice.
What are we doing?
Right where your cursor is, well,
Yes.
above malice murder, there's two paragraphs that right now are redundant.
This second paragraph, we can delete as charged in this case.
This?
That and the paragraph above it both say the same thing in different ways.
Criminal gang activity means we don't have conspiracy to commit, right? Yes, we do. Sorry. Well, that's the definition, right? So what are y'all saying?
You're saying as charged in this case, and we kind of.
So, I mean, I think it needs, I don't think we need that, but murder, possession of marijuana, we don't have these anymore.
Okay. Your Honor,
Yes.
may I sit so I can see my screen? In count 57.
Yes.
And again, maybe I'm just not understanding this. Maybe I'm just tired. In count 57,
Mhm.
the criminal street gang activity is alleged to be based on the commission of one of
Possession of marijuana with intent to distribute and possession of a firearm.
right? So, but not murder. You have murder, but the problem is the way that it's worded with 50,
Which is why we may need to separate this
with
one out.
57. That's what I'm trying to say is murder is not included in 57 gang activity.
I understand.
Okay,
But
thank
he's
you.
not going to be, they will have the language of each count when they do guilty or not guilty. And so when they get to count 57, the gang activity alleged against your client is not going to list murder. It's just going to list possession of marijuana with intent to distribute and possession of a firearm as alleged in certain counts.
Okay,
Okay.
as long as it's clear in that
It's-
form,
Okay.
then I'll be okay with that, Your Honor.
58, 59, 60. Okay. So we're now to, we don't have to define this non-pattern charge because they're not being charged with it. Nor do we have to do possession of a machine gun.
Do we have?
We do have to do possession of a firearm. 131 though, that is a pattern, right?
Well, Your Honor, machine gun is an overt act, so if we're.
Okay, well, why don't you just give me that again when you send all of the overt act things? Because I'm may actually. It's already in this or somewhere else? Right, but is it dropped into here anywhere yet? Okay, all right. Okay, we just need to pull the pattern for 131 then and put it in whatever that document is that Mr. Atkins sent. Okay, so. Why does this say, oh. It's just any felony, right? If it's 131? Okay. We might need to look at that whole thing again to make sure it's correct, but. All right. So possession of a machine gun. Laura, can you just lift that and put it in with the rest of those overt act explanations? Thank you. Possession of marijuana. We don't have that, right?
Correct. Well, that'll be.
We have it,
overt,
possession with intent to distribute, right?
The marijuana, we do have that for the overt act.
Okay, well, that will need to go in where the overt acts are explained. So did y'all send that separately? Laura, will you just make sure that one gets grabbed also? We only have marijuana, right? No controlled substances now? I guess we'll still need this for some of the charges that exist, because, right? The, yes.
Although, you know.
Yeah.
Could you scroll up?
Mm-hmm.
please?
More.
Well, if it's the over, I don't, in, I mean,
Good eye.
And there it is again in the next paragraph.
I'll see now you're taking.
We're going to do a word search later.
It's awesome.
Yep. It's everywhere.
It's everywhere.
Okay.
Right there, Sue. In the Citizens of Belgium, Runner, if you go back up to equal access, the second line.
Thanks. Okay. We still haven't gotten the verdict form, but mm-hmm.
The state did send a word.
Oh, I'm sorry. Yes, I know. I mean, we haven't settled on one yet, nor have we reached a point of discussing beyond what we've,
I
yeah.
want to make sure.
No, yeah.
And I would really like some time to, I understand that you gave us a heads up on the verdict form, but I'm still going to need time to weigh in on that.
All right, so I think that's everything for this one, other than making sure of that. But now we need to go through, is everything pattern for the other crimes that are only other acts? Why don't we get out of this? And do you want this forwarded again to you so everybody can take a look at things that we might have missed?
Sure. Could we say this under a different title?
I mean, I guess we could do that. Yeah.
didn't mean that sarcastically.
Your
I
Honor,
know.
Your Honor, this is probably, of course, but the RICO that we worked on as well, instructions.
It's embedded.
Okay.
Yeah, it is
Thank
in
you.
there now, thanks. Okay, let's see. Are you going to be the one to share the,
I can, but I.
which would be
can
easier?
put
Okay,
everything in
let's
there.
everybody take a minute.
Come back, 'cause I know I'm missing some, but next one's good.
What's the date? November what? Thank you.
So,
So I'm going to title this November 20th, jury charges with RICO, and then Laura, you can send it. Whenever. They don't need that right now.
well, we'll add, because we'll have to add all this in as well.
Okay. All right. And,
So I'm sharing this now.
okay. Is everything that would cover anything that's a crime in the overt acts.
Except there may be a couple we need to add back in based on
Okay.
other things, but.
What is this called? This is jury charges thing. What is it called? Okay. What a good title.
So, okay. Mr. Weinstein just brought up a point to me.
Okay.
With these overt acts, the pattern charges refer to people as defendants,
Mm.
and I don't.
Yes, no, we definitely don't want to say that. So maybe we can just do a global replace of someone,
How
a
about-
conspirator.
How about actor?
Person. I definitely,
Person?
a conspirator.
The
I
person.
think
I don't want,
comment on
I mean, okay, but maybe the person assaulted another person. And that's just going to get confusing.
actor.
Perpetrator? Perpetrator. Okay, so do you know how to do a global replace? Okay.
or maybe
Alleged.
alleged
perpetrator.
perpetrator, yes.
Okay. All right, so we'll change defendant everywhere in there to alleged perpetrator. And
That's why conspirator is not appropriate, because you have to be either an indicted or unindicted conspirator to make everyone guilty. You can't just be some,
A conspirator, maybe?
yeah.
And alleged, because,
Alleged conspirator.
well, no, because they'd have to actually be a conspirator.
Right, but I'm concerned if Your Honor gives jury instructions saying the conspirator, that is not intentionally, but.
No,
it's
but
a
might
kind
be
of-
saying, hey, they are conspirators, and we don't want to do that. That's for them to decide.
I give them, that's fair.
Okay, so the perpetrator.
Alleged perpetrator.
The alleged perpetrator, sorry. All right. All right, so there are two non-pattern charges. Criminal use of an article with an altered identification mark. Can y'all see that on the? I'm not the screen share right now. When Ms. Persfield's doing like 7 things at once.
That's where
Thank you. Alleged to have done, whoever had this. I mean, we want to get rid of the language that's not applicable, so
It's just concealed.
conceals. When he conceals,
And it's Act 53, Your Honor, in the indictment,
thanks.
which Trontavia Stevens, and then it goes on, criminal use of an article with altered ID by possessing a firearm from which the accused knew the identification mark had been removed for the purpose of concealing and destroying the identity of said article.
Oh, okay, so it's, a person commits the offense of whatever that is when he possesses, right? A firearm?
Yes, Your Honor.
I'm sorry, say that one more.
Okay, so when he, and then get rid of from or all the way through possession, and then change it to possesses a firearm. Yep, which he knows. All right, and then that's it. Then I think it's fine.
You can take out nameplate, 'cause it's serial number, right?
We can, yeah. The manufacturers, what was alleged?
Serial number.
Okay. Serial number.
We can try.
Or are there distinguishing?
And it
What,
said,
what it alleges is the identification mark,
correct, Your Honor.
which, did y'all mean that to be the serial number?
I believe, Your Honor.
Let's keep, or any other.
I think it's
distinguishing
fine the way it is.
identification.
Okay, and then implied, what is this? Why do we have that? Where did that come from? Number 10.
I include that in all my murder cases. Abandoned malignant heart isn't defined. It's from, obviously, it's a non-pattern charge, so I get.
I think we have malice in there, and we say malice can be, it is such, I'm paraphrasing, malice can be formed within an instant or something to that effect in the pattern. I think this is unnecessary because we already discussed malice in the pattern.
The pattern just doesn't define what an abandoned and malignant heart is. It says an abandoned malignant heart may be inferred from the circumstances.
Why do we need to?
Hang on.
define abandoned and malignant heart?
Hang on, y'all. Let me get to the patterns. So it's,
For the reason that just Mr. Bachus said.
for malice murder. Because the pattern says you may also find it when all the circumstances of the killing show an abandoned and malignant heart, which nobody knows what means, even though there have been case after case after case about what it means.
And maybe we don't need the first
So,
sentence, we just need the abandoned and malignant heart sentence.
so yeah, part of it's covered. We say you may also find malice where there does not appear to be significant provocation in all the circumstances of the killing show an abandoned and malignant heart. So that first sentence is already covered. Oh, and the second, well, sort of the second sentence. So basically you're looking for a definition of abandoned and malignant heart.
The first sentence I just put in there.
Okay.
Where it should be put in the pattern chart. I can go-
Is there any definition in the, like, bench notes of the pattern that define it? All right, I'm not going to do that. Delete that one. Is that everything? Those are all of the charges that are in the,
I just added possession of machine gun.
Okay.
into here
Well,
because it's
all right,
It's out of the other set, but we'll go figure out how we're gonna do that.
possession, oh,
And then I guess you're going to need to
Need
add the
to send
codeine and the
that's a machine gun.
cocaine back in if it's not there.
Wait, they don't have to have possessed a machine gun during other crimes. They just have to have possessed a machine gun, and then we need to define what a machine gun is. I think we lifted the wrong one.
That's what we have in there.
Okay, well, we need to work on this one. That a perpetrator possessed a machine gun. A machine gun is any, yes, period. Yep. I think that covers it. Right?
And then, I don't know what happened to codeine one, but we'll get that. So codeine
131, I don't know.
Codeine
And cocaine. Is there anything else? We might need that.
Theft.
Theft by receiving stolen property.
Those are overt acts that aren't, okay. Well, can you quickly grab the pattern for that? Is it theft by receiving stolen property?
Yes, ma'am.
All right. Is that a separate?
C- c-
I'm gonna send it to-
Can we go back to the machine gun when you get a moment, Your Honor?
Okay, yes. Theft by receiving stolen property is 2.64.80, which Laura, I can grab and drop in here, but will it show up on?
It should.
Okay. I'll just put it right there. Does that show up? Oh, you'd have to move it to that part. I put it right above possession of a machine gun. Is it there? Yeah. Okay.
Okay.
And obviously we'll need to change defendant again, but
Can we go back to what you removed in machine gun when you have a moment, Your Honor?
I'm not the one moving it.
Oh,
so-
okay.
So yes, but we have to be patient with Ms. Persever.
I believe you removed language about commission of a crime. That's in the statute, and it's also the way.
On
It-
machine gun?
Yeah, it is. It's A1. It shall be.
What's the statute?
It is 1611-160.
Thank you. I've also never done a possession of a machine gun trial.
Well, there you go.
16, 11, 150. Okay. 160.
On the machine gun? I will as soon as we get there. I have to get this added back in.
Oh, how interesting.
Yeah,
How odd.
I don't know why that is, but I'm not going to question the wisdom of our legislature. Today,
Okay, so it shall be unlawful for any person to possess a machine gun during, okay, so I guess we'll go back and lift them back.
and then in the count, there's a specific list of the offenses.
So it's only alleged that so that would be the two that are left, the possession, during the commission of possession of marijuana with intent. Are
Actu-
other people charged with
Yeah.
possession of a machine gun?
Yeah, there are. And so there's a list in 62, which probably should be included
Yes.
here, which is criminal street gang activity, possession of intent to distribute, and possession of cocaine. I could read those off, Ms. Percival, if you'd
Well,
like. Okay.
for, as it's indicted, it's participation, it's everything that's in 62. Is that what you just said? Okay.
Yes, everything in 62,
All
Your
right,
Honor.
so we can lift that from
Okay.
the indictment.
Thank
Or
you.
Laura can just type it right now. Okay, what else?
We'll need to add back in, Your Honor, possession of methamphetamine with intent to distribute, hydrocodone with intent,
Hang on just a second. Why are we adding those back in?
because those are Act 69 and Act 70, they're overt.
Overt
acts.
acts. So are there overt acts that are possession of a machine gun?
Yes, that is,
And those are 69 and 70?
no, I'm sorry. Possession of machine gun is 188.
So they were alleged to, Kitchens and Williams were alleged to have possessed meth and hydrocodone with intent to distribute at the time that that raid occurred?
No, sorry, two separate conversations, so I should finish.
Okay. So the machine gun one is fine now.
Yes,
And you're saying separately as offenses that we explain, got you, we need to do possession of meth and possession of hydrocodone with intent to distribute.
and possession of MDMA, which is Act 77.
Okay.
Hang on, real quick. Which ones are intended to distribute and which ones are possession?
All of those are intended to distribute.
Methamphetamine, hydrocodone, and MDMA.
Those are all intended to distribute?
Yes.
Okay. And is there, other than the cocaine, is there anything that's just possession?
Do we,
No,
do we still have a simple possession of marijuana as an overt act?
I believe we do.
I don't know, and I know we're all speaking at once, but I don't know if you would need to do MDMA because it's Act 77 and it's just referencing what Mr. Nichols had been previously convicted of to make him guilty of possession of firearm by a convicted felon. So we don't-
Ah, so we don't need that. Thank you.
Thank you.
So it's MDMA, no.
And the hydrocodone, no.
No, we need hydrocodone.
We do?
Yes.
We do, that's.
Oh, sorry. Okay.
Act 70 for 50.
Sorry.
And if we don't, I think we added it back, but possession of codeine with intent to distribute.
Yeah.
Yes. I'll try to go back for a double check.
Your Honor, I'm double checking. I'm just control Fing possession in the indictment to make sure I'm not missing
Okay.
anything. And there is Act 49 has possession, simple possession of oxycodone.
All right, I think we're getting to the end. But I need a quick break. Because so I'll be back in a sec. All right, while we were on the break, I think Ms. Percival caught a couple more charges that need to get included that were, I think, maybe drug charges as well. So we'll get those included. And then we will send out to everyone to take yet another look at. These jury charges, including all the RICO we just did, the overt act crimes that we are just now including, and then hopefully everything edited correctly as to the rest of the charges. Acts, they're not counts that we need to set that off somehow, and I'll just kind of say, hey, you're gonna get a list of overt acts, and some of them are crimes. So I'm giving you the definition of those as well, something like that.
I think that makes sense, Your Honor.
Okay. All right, so I know the state has provided a jury form that they're gonna try to further tailor now that we have a better concept. Tedious to get through, but I think it was very important that we did it, and it kind of took everybody thinking it through to get to there, so I appreciate that from everybody. And whatever y'all come up with in the way of proposed verdict forms, just forward to Ms. Percival. We'll look at all of that. I know y'all need to know when we're going to start the closings. We don't, the only things we need, and you'll still need to put those stipulations together. Acts that are alleged to also be an act of, a gang act violation. And what a gang act violation is, but when we did that, we only did it with regard to the crimes that were substantive counts of the indictment charges. And there may be some, there's like an aggravated assault or something like that and other things. So
There's an attempted murder, there's a conspiracy for murder,
so we're going to need to,
drug sales.
I think to keep it clean, instead of trying to.
still
put
keep it
together-
separate?
Yeah, I think maybe we just.
Okay.
The same thing, except criminal gang activity. However we have.
For purposes, the overt acts includes, okay.
Do you have to do that? And I'm just saying, I'm throwing it out because the catch-all says any act of violence, drugs, it lists like the categories. I mean, an aggravated assault is clearly a violent crime. It's a suggestion to make it less wordy, but
I
mean,
I agree with Mr. Body.
Okay.
I think I do, actually, with Mr. Body. I think that, when we're defining, I don't understand the need, I wasn't gonna die on that hill, but I don't understand the need to specifically say
these things
our
equate
criminal
to-
gang activity, and that applies to when we defined it earlier and now. I think we can just, the problem is the definition of criminal gang activity in statute is very long, and then it has the catch-all, and then it becomes,
yeah,
and then you're making references to different statutes as well. Like certainly I understand the crime of violence, but then there's the catch-all, and then we would have to reference the RICO statute.
mm-hmm. And that just gets to be a nightmare. And so when we are doing it for the overt acts, what are y'all saying? Or what are y'all saying that y'all agree to?
I think, I like what Mr. Abate said, but I also think it's gonna get cumbersome if we expect them to parse through everything, but, so I would just do it the same way we did it in the, for aggravated, what is it, aggravated battery? Aggravated assault, would constitute, if proven, would constitute criminal gang activity. We cut and paste from the first part defining criminal gang, or it and pasted it here as well for the charges for the overt acts, except when we have that little explanation of criminal gang activity and other, we just put aggravated assault.
Can I make another suggestion?
Mhm.
Your Honor, charge on the overt act crimes first or second? Because my thought is if we were going to charge on the counts first, you can maybe say criminal gang activity as previously defined, and then just put that last paragraph versus restating the entire charge, just saying criminal gang activity also includes this, and this, so that we don't have to say it twice. That may or may not be simpler, but I'm not sure.
Okay.
I think sorry, I'm interjecting, but I think the issue with that is the overt acts have to be with the RICO charges. Or we say something,
Yeah, I mean,
it could be later, but it has to be clear that these are related to, I mean, because it would, because the overt act is mentioned in RICO, and so it either needs to get restructured or we somehow refer back to it, but it seems confusing if the overt acts are listed way totally away from all the RICO.
Maybe charges for overt acts and parentheses as alleged in count one.
Or if you're doing the overt acts first, you don't have to repeat it the second time
I
when we're
kind of
talking
went
about the
thinking about
charge.
doing the overt acts first.
I think my ultimate point was, I don't think we need
Yeah.
to refer back to.
All right, the gang counts against Mr. Kendrick and Stillwell are 50, 51, and 57, right? So what I could say is, after we define it, for purposes of counts 50, 51, and 57, murder, blah, blah, blah. Murder, possession of marijuana with intent to distribute, possession of a firearm during the commission of felony constitute criminal gang activity. And then wherever we're doing it for the overt acts, say, for purposes of the overt acts, whatever they are, constitute criminal gang activity. Would that make sense?
Yes, but we have another problem.
Okay.
One of the overt acts is section D of the criminal gang charges. That would be number 182 unless that is out.
Oh, maybe it's out.
I think that's the leadership. It's out, oh, yay.
Is it out? I doubt it. Oh, excellent. Okay. I just mean excellent in that it's one less thing we have to deal with. Okay. All right. Good catch, though, Ms. Persifield. So, thoughts as to whether I do the overt acts in the context of the gang, of the RICO count, or whether I just walk through, here are the definitions, here's how you prove the substantive crimes, the counts in this indictment alleged against these defendants. And then after that, hey, there are also some crimes that are within the overt acts, crimes alleged within the overt acts. Here's how those are defined.
Maybe some sort of transition, like as you see the indictment, or as you see the indictment, for acts, some of which are are alleged crimes, and then I'm providing these definitions in regards to the overt acts list or something like that.
The question was, any preference as to whether that's done right after I explain RICO or after I explain all of the substantive count crimes?
Yeah, I think I'm right after. Rico, Your Honor.
Okay.
It makes sense to just close that gap.
Okay.
But would you include these charges in the
I'd have to.
paperwork or
Things
just
like-
tack them on at the end as an appendix? And then you could say, look,
No, all of everything I read is going to go out to them.
no, I want it to go out. I'm just wondering if the charges for the overt acts, if you embed it in the middle of the document right after the RICO section, or I think it may be more helpful to help them distinguish these from the acts and the count, is if you say, look in Appendix A,
Right.
and in Appendix A, you'll see how to understand the charges for the overt acts.
It's fine.
Is that okay? with you?
Good idea.
I think we agree on.
Man, look at that. All right, so Ms. Persfield, you noticed something else?
Yes, sorry.
Better now.
We don't have in the overt acts firearm possession, because there's a number of counts that are possession of a firearm by a felon. There's also a couple of counts that are possession of a firearm by a probationer. And then we have the charges against the inmates.
We don't know. The probationer one is the same, is the pattern that you use for possession. of
Yes,
firearms.
substitute probation.
So we'll add that, but then there's several: possession of a weapon by an inmate, possession of a phone by an inmate.
I'm doing that one right now.
Okay. And there's, I don't know if it's in or out, but those.
He was using.
Okay, all right, but there are some possession of contraband inmates.
Yeah.
Or acts, alleged acts.
Murder is alleged as an overt act, right? If I am defining all of the crimes that are overt acts first, within the context of RICO, I'm just afraid that I don't know what I'm afraid of. It seems worrisome to me, and to some degree, that then that would be where they find the definition of things that they have to substantively consider against these defendants. You know what I'm saying?
Your Honor, my idea was if you use the appendix for crimes not otherwise defined.
Right. I agree with that.
All right, but then the order of it, I just don't think,
I would say we would use I agree with Mr. Atkins, but I would think that we would do the appendix for the overt acts types.
I agree. That's what I'm thinking.
Well, yeah, the
too.
appendix comes at the end, so.
Right, but when we, when we charge it, when I charge it, instead of
Oh.
saying, all right, now I've explained RICO to you, and now I'm going to tell you about the crimes that are overt acts. Here's how each of them is defined. I'm just going to say, I'm going to define those for you. If there are any, I'll just get to it later. And I'll do everything that's a count of the indictment. And then I'll say, you know, whatever I'm going to say. My brain's fried at this point,
Yeah,
but
thank you. I'm just a beat.
RICO
mind right
refers to certain overt acts, some of which are crimes. Some of them haven't. Here's the definition. Okay.
Okay.
Okay, what else?
So this is, so basically here under overt acts, this is in the RICO portion.
Mm. Doesn't it? I don't know. We'll figure it out tomorrow. You and I will figure it out tomorrow. Are you saying put that language there?
Well, that's what I'm wondering, is if this is in the RICO, I mean, not all of the
Yeah.
language, but a
Okay.
reference to
Mhm,
where overt acts would be.
mhm.
Well, can't you just put something in there to the effect of see Appendix A for definitions of,
Well, that's the question. Is that-
Okay, yeah, an overt act may, but does not have to be a crime in and of itself. That would be the place to say that. Some of the overt acts alleged in this indictment
are crimes?
are
Are allegedly crimes?
are, well, some of the acts alleged in this indictment, if proven,
Would be violations.
would be criminal violations. Would be crime. If proven, would be crime.
Are you both typing into the same document?
Would be crimes. Some of the overt, if proven, would be crimes. I'm just going to highlight that and think about that tomorrow in very Scarlett O'Hara fashion because my brain is not working anymore. Mhm.
Helps, when you go through the indictment, the way we alleged it, where the overt act is a crime, we've identified the statute that violates. It's very easy. once
Okay.
you look at it, they'll know which ones.
Okay, great. I may even say
of-
that.
Of the overt acts, the
Those
subset
have
of those
a
that are
site.
crimes, those are clearly identified in the allegations, and they'll have that document. So they don't have to guess which is which. It'll say it's a violation of the statute.
All right, I may just say something like those will have a cite to a criminal code section. Okay, so I'll think about that more and come up with some language. So,
Tomorrow is another day.
yeah, it may be tomorrow before that gets hashed out, but
We are working on a redacted indictment as well.
Okay.
So we'll get that tweaked and get that over to the court and everyone as well.
okay. I think that we need to get together tomorrow and look at all kinds of things again, like hopefully a final jury charge, a jury verdict, what evidence is going to go out, the redacted indictment, all of those things. Which means that closings, which I think are going to take more than a day, don't y'all? I mean, if, I mean, y'all said, I don't know, it seemed like the time periods y'all gave me. Once you think about the fact that people have to take bathroom breaks, that people have to eat lunch,
I rarely take a bathroom break, Your Honor.
that's 8.5 hours by y'all's estimates without any break. So that is more than a day's worth of closings. So I think that means we start closings on Friday, but we probably don't finish closings until Monday. And then I charge the jury, which I hope, I have no idea how long the charge is going to take, but I would think that the rest of the closing and the charge can be completed Monday. They get the case Tuesday.
Yeah.
Well, the end of the day Monday, but I mean, they're not going to do anything in that little amount of time unless I talk really fast while I'm charging. They have a short day on Wednesday. They have a short day on Tuesday also. Oh, wait. Mm-mm. This is,
Maybe it won't take
oh,
them very long.
God, they do. These jurors, and I mean, they are trying to live their lives. I can't remember why we have a late start next Tuesday also.
John, would you consider, I am very afraid of
Would I
closing up.
consider doing all of this after Thanksgiving?
No, that's not what I'm asking. No, that's not what I'm asking.
Because.
That's what the state's asking.
And only because, Your Honor, if we close and they take breaks and say if we don't get a verdict back on Wednesday, you're going home, talking over the Thanksgiving dinner, and you're doing all of this, and you hope that they don't, but you don't know what
Well,
is.
I'm instructing them not to, and whether they have gotten the case or not, they're not supposed to be doing that.
I agree.
And
I agree. But we would,
I'll get back to you.
we are.
Go ahead.
I think it's, tell me not to say anything. I'm not.
Okay.
Matt?
Mr. Sharp.
This is my concern about, Friday.
Okay.
State does their opening, closing on Friday morning.
Mm-hmm.
Myself and Mr. Weinstein close on
Mhm.
Friday. Jury goes home for the weekend. Come back Monday, and then all they hear.
It's
from
like
us
the
is-
only thing they hear is the
So
states.
would be, I don't think everyone's going to take this on this thing. I would ask if we could close on Monday. Whatever we don't get done, I don't believe it would be much on Tuesday. And then we could give the jury instructions Tuesday after the break, going for a weekend. And then-
Yeah, I mean, I agree. The other thing we can do is start the closings and have the state do their open close tomorrow afternoon. And then we finish with the closings on Friday. And then I instruct them on Monday. And they get the case on Monday.
I like that idea better.
Hmm?
I like the other idea better.
Which was
Monday.
start the closings on Monday, finish them on Tuesday, which is a late start anyway of 11 at the earliest because of a medical appointment. And then I may or may not have a chance to instruct them on Tuesday, but I could instruct them on Wednesday, but then they have all of that, but then they don't actually start deliberating until they come back from Thanksgiving.
But they would have the written instructions.
That's true. They would have them in writing, Your Honor. It's not like they would
Well,
get them over the Thanksgiving break.
Or we could,
yeah, I mean, that's,
or Your Honor could instruct them when we get back.
No, it's not. They're not actually listening.
hmm?
I think they like, I think people are more visual anyway. They're less likely to listen for 2 hours. The charge, that's the whole point of setting.
I don't understand what you're saying, because,
When the court charges the jury, they're blank faced. So that's why it's always so important to send it back like you suggested you do, because when anyone talks at you for more than 15 minutes, most people stop listening. So, not saying that they do, I know I do.
Then it would seem to be in the state's interest to not have a 5-hour closing, Your Honor.
Easy.
Okay. Yeah, I like your idea for tomorrow, Your Honor, but I don't think the state, I guess the state would not agree to.
on Thursday to give closings. So if that's what I decide, that's what happens. When it comes down to it.
I'm just not looking to throw them under the bus, but I do like the idea for them starting tomorrow, and then we would wrap it all up Friday. Or wrap up the closings Friday.
And you like that idea.
I do like that idea.
Well, only reason he likes that idea is the jury charge won't be complete until tomorrow. And so he'll have all night to process and, synthesize all the information that we'll continue to go over tomorrow.
Yeah.
Mr. Abate is not lying. It's my duty of candor. I have to tell you that
I appreciate that, Mr. Weinstein, that you take your duty of candor seriously.
very seriously. Your
All
Honor.
right, so closings Monday, maybe we finish Monday. If not, then we come in late on Tuesday and finish closings, and then maybe we'll just have to see. I charge them either Tuesday and they get the case, in which case I probably just won't.
Well, because
I mean, are they going to deliberate for one day and then go to Thanksgiving?
I would say we could probably close and charge on Monday after Thanksgiving, and then they'll have.
Wait.
We can certainly not close and charge in
I'm
one
sorry,
day.
not close, I meant
You
to say
mean
charge.
Tuesday?
Charge.
No, but,
On Tuesday?
On Tuesday.
but I think they should, if we charge them on Tuesday, I think they could begin deliberations immediately thereafter, correct? I don't think
Depending
they-
on what time it is.
We have court Wednesday, correct?
I mean, we're scheduled to have court on Wednesday.
what are the hours?
No, for the whole day.
Well, then that gives them a whole day to deliberate.
I
That-
had said, I had told Mr. Matthews we
Right.
could quit it too, but Mr. Matthews is no longer. I mean, the jury would,
I don't recall you telling the jury either way about the
Wednesday.
Thanksgiving. We had that conversation at the bench.
Yeah, I don't think I ever did, honestly. So I think they think they're here all day Wednesday. And so they could be here all day Wednesday.
What if when you send your message about coming Monday,
Uh-huh.
let them know that we're gonna have extended hours on Monday. We start at 8:30 and we'll go till 7, so all the closings get done Monday.
And just get all of the arguments. We could do that.
First thing Tuesday, do the charge.
Well, at 11 a.m. or whenever they're all here, do the charge, get it.
You could extend Tuesday to 7 o'clock, so since they're not getting it till 11. Or whatever time.
Mm-hmm.
That's the state's suggestion to keep them here till 7, just to make that clear.
I'm not staying here until 7 on 2 days, but. And then are you saying have them come deliberate on Wednesday and then take a long weekend and then,
Yes, Your Honor.
okay. All right. That's what we'll do.
Thank you.
Okay. So I still think we all need to get together tomorrow. How about 10?
Oh.
Unanimous agreement on the vote.
All right.
and there was much rejoicing.
All right, thanks, everybody. Jury charges and yeah.
Hey, Your Honor, I know you don't have control over
In
the
order
sheriff.
to get him here?
They moved him at 2 a.m. They woke him up at 2, moved him to Rice Street for whatever reason, then brought him here because I don't know all the thinking behind it, but come on. Can they please need to wake him up at 2?
No, not the elected sheriff.
I understand that. I
Doubt if the
understand.
elected sheriff knows that either, frankly, but, to my great and devoted deputies, can you all please get word to whomever is in charge of getting the defendants here to, if at all possible, not wake anybody at 2 a.m. to start transporting them for a 10 a.m. court hearing? Thank you. I really appreciate that.
Thank you, Your Honor.